You're aware that documented evidence shows that your signature is on this leak, correct?
Yes, he would ask me to sign things and I would. Often he sent me a last page on the email while I've been at work and saying sign this and fax it back, so I don't read the documents.
So your story today is that you didn't know anything about this. Is that correct?
I knew a little about it.
But you're asking the court to undo this deed of trust that you signed, correct?
Yes,
We disclose persons with knowledge relevant.
Yeah, I'm not buying it. You all disclosed her. Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Thank you. Counsel, who's going to be your first witness?
My first witness here will be Sharon Lopez.
Okay.
And both of our witnesses, other than my client, or myself for fees potentially, are experts. So I would ask that they be from the attorney and corporate.
Judge, they haven't been qualified by you as experts yet.
So
Mr. Stanford is an attorney and colleague of his partner of mine. So I think the same application for the rule would be that he would be able to be present. He's been designated as that.
Ours have been designated as well, Your Honor.
okay, Attorney Bean, you stood up. I didn't know.
Oh, sorry. I just realized I was only one sitting.
Okay.
But I was just gonna say, one is the custody evaluator, one's the counselor for the kids.
And Your Honor, I would also object, well, I'll get there in a minute.
Judge, can we have one attorney per argument instead of both of them?
Yes. Who are you all going to direct and
So
cross?
I will be calling Sharon Lopez
Okay.
first. I will then be calling Jeannie English, the children's therapist, who's also an expert and been
Okay.
designated as one. And then I'm not sure what order we're gonna go in, but I will either be calling my client, Marjan Hashmi, and then my co-counsel will call Suleiman Hashmi or reserve him to cross-examine.
Okay.
Then they cross-examine any other witnesses they have.
So I'm taking 3 witnesses, my co-counsel is taking 1.
Okay.
And Judge, just to be clear, we were told we have 40 minutes assigned this morning?
Yes.
Okay.
And I haven't started the time yet, just FYI.
Thank you, Judge.
You're welcome. So the counselor and the custody evaluator, would you all please stand? Okay, so everyone else, is she a witness too?
Yes, Judge.
Okay, so the counselor, who's going first? The custody evaluator?
Sharon Lopez, correct.
Okay, so she can go ahead and take the witness stand.
Thank you, Your Honor.
The counselor and the young lady back here, the rule, you're invoking the rule, counsel?
Yes.
Okay, so the rule has been invoked, which means that you'll step outside. You can sit, there are 2 conference rooms. As soon as you go outside of this door on either side, you can sit in there, but you're not allowed to speak to anyone or even each other about the details of this case, okay? And whenever it's your turn to be called for testimony, then the bailiff will come and get you. Thank you.
And Judge, I do have an objection to father's, the one witness that just left the courtroom. They did not tender this court with a copy of a pretrial witness list for this court's rules, so I'm going to object to that witness testifying today.
Judge, she is somebody that was disclosed on their responses to disclosures as persons with knowledge of relevant facts.
You all disclosed her?
We did, Your Honor, but they did not comply with this court's rules for the witness list, so I'm going to object to her testifying.
It's somebody on their list, Judge.
How does that work? So are you calling her as a witness?
No, Your Honor, I have no intention of calling her. She was listed in disclosures purely because she was a person with knowledge of relevant facts, never someone we intended to call as a witness.
Okay, counsel, did you disclose her as a witness?
I believe she is on my disclosures, Judge. I did not do a witness list.
Okay, if she's disclosed, then, I mean, it's proper.
Well, Judge, my only objection is that this court has very specific pretrial rules for summaries, property spreadsheets, requested relief, and a witness list. They didn't comply with any of it. We don't even have an updated inventory for husbands since June of 2025.
What? I don't think my policies and procedures override the discovery rules per se. I mean, if she was disclosed, then why can't she be a witness today?
Because because Your Honor, if I may, a witness list is different than persons with knowledge of relevant fact.
Again,
The discovery rules doesn't mean that, just because someone has knowledge of relevant fact, doesn't mean they're going to be called as a witness at trial. The witness list is specifically for that reason, for us to prepare for that witness. If someone is in the disclosures, but not, on the witness list, we're to assume they're not being called at trial.
So you all disclosed her with relevant facts. Which relevant facts were you disclosing her about?
That was to reserve the right to cross-examine.
Just in case they called her.
Yes, Your Honor.
then they are on notice. Judge, it is no surprise because what the discovery rules say is that the court should not allow them if it is a surprise to them. It is not a surprise to them. They have known all along. And Judge, again, I'm gonna ask one attorney for argument. They have known all along that this is the party's adult daughter, Ms. Hashmi, has information that is relevant today.
So it would be the same thing. You disclosed her for cross. So if she calls her as a witness, you'd be crossing her, right?
But they're surprised because she's not on the witness list.
There is.
But you all disclosed her.
We've disclosed her as a person with knowledge of relevant fact, and then they did not put her on the witness list. Therefore, that is a surprise because we're to assume she was not being called as a witness, even though she might have knowledge of relevant fact. We disclose persons with knowledge of relevant.
Yeah,
fact.
I'm not buying that. You all disclosed her. It was obviously something that she had that you all needed or thought that you wanted, which is why you put her on your disclosures. And if she calls her as a witness, that's your opportunity to do exactly what you said you were going to do, which is to cross-examine her. So, anything else?
Judge, as to the briefs that they filed,
I can't see them yet. I can't see the briefs yet.
I think one of the briefs, Judge, just to put it on the record, is that they're asking this court to affect the lien that is owed by the parties on a trust. So the parties set up a trust, the SMH trust, back in 2012. If I
Judge, I'm gonna
remember
object to
correct.
counsel testifying about facts that are not before this court.
I'm not testing.
Well, it sounds like she's referring to what's in your brief. Is that what's in your brief?
In part, Your Honor, I do have a copy for you if you'd like one.
Okay, you may proceed. Is that the brief?
Yes, Your Honor.
That long, you filed that for me to consider for this morning?
Yes, Judge, it's only 4 pages. I have the case law attached to it.
Oh, okay. I was about to say.
I don't think that filing 45-page things unless it's a motion for summary judgment.
Okay. Whew, you made me nervous.
I have a copy for opposing counsel as well. Although it appears she's already seen it.
I've seen it, Judge. I just haven't had a chance to review it completely in detail or to respond because I just got it maybe about an hour or two ago.
And Judge, this is a bench brief and this is something I'm going to argue with the court one way or another in closing arguments. Again, I'm offering this brief as an aid to the court on some substantial property issues in this case.
My problem is, Judge, that from what I understand from her brief and her requested relief is that she's asking you to affect an interest of the SMH trust. Because the SMH trust holds a deed of trust that is payable if this home gets sold, Judge. The trust is not properly before the court. They have not interpleaded the trust. They haven't served anybody on behalf of the trust. Moreover, Judge, some of the exhibits that you're gonna see, both of the wife and myself, is that there is a trust lawsuit pending in civil court right now that is taking care of that matter. And they are asking you to issue orders just to circumvent that court. And that court is the one that's gonna make the decisions about the trust.
And Judge, may I please respond because that is not correct.
About this.
There are several things in that statement that are not correct, Your Honor. Actually, Ms. Olvera made this same argument to Associate Judge Lee in February when we were set for the first pretrial conference, at which point Judge Lee instructed me to serve Mr. Hashmi in his capacity as trustee. And the reason why we have served Suleiman Hashmi in his capacity as trustee is because, again, he has abused the trust and we will leave his abuse of the trust to the trust court. However, what he has done in his violation as trustee is he has improperly encumbered homestead property. And it is necessary for us, and this court actually has the ability to order him to release a lien, which is, by the way, an improper, invalid, and void lien, to make a just and equitable division of the community estate. We do not concede that that lien is proper, that lien was fraudulent, that goes to our overall argument for fraud, and the statement that Mr. Hajmi was not served is incorrect too. We filed a fourth amended petition for divorce per Judge Lee's instructions to add in the trust for this limited scope issue, served him with it, even have a return of service on file with the court. And if the court needs me to find the exact date that we served him, I can pull that up for you. But he has been served, he is on notice, he is here today as husband and in his capacity as trustee. And again, we are asking this court for a very limited thing that the family law court has permission to do under Texas Family Code 5.001. To find that that lien was improper, because if this house is sold or divested by this court, guess who stands to benefit from that, Judge? Suleiman Hajmi in his capacity as trustee. And you'll hear plenty of evidence about that today.
I guess the court's question is, why wasn't this filed as a summary judgment?
Judge, they waited until after the pretrial, after our.
Wait a minute, Attorney O'Vera, I want to hear the answer to that. Why wasn't this filed as a summary judgment?
Because we want to be able to cross-examine Mr. Hajmi.
Okay, Attorney O'Vera?
Judge, they wait until the very last minute to bring in new claims, to bring in an intervener. The intervener is not allowed to hire an attorney of his own. I don't represent the trust, Judge. I represent Mr. Hajmi. The trust is in front of a civil court, and they are trying to circumvent the jurisdiction of that court that is going to make decisions regarding the trust. White has already brought claims to that court, Judge.
Pen right there. Is that true? Is there already a case pending in the civil court regarding this?
There is, Judge, but because there is an invalid lien on marital property, we were obligated to ask this court to release that lien, because if that lien is found to be valid by this court, which this court has the authority to determine whether it is valid or not, that if the house is sold, the trust will essentially be enriched in the amount of $2.5 million.
What happens if I make a ruling and the civil court makes a ruling too? So you just have two orders?
Civil court is trying to determine whether he is removed as trustee. We are trying to ask this court to find that a lien that husband improperly put on the marital property in his capacity as trustee to be invalid, which this court has the authority to do. This court has the authority to find that this lien was improper.
So the civil court is pending a ruling from me?
No, Your Honor.
They're two separate issues.
Judge,
The,
yeah.
Hold on 1 second. Who's going to speak?
I can speak, Your Honor.
Okay. Is the civil court pending a ruling from me to determine whether or not the lien is valid?
No, Your Honor. And actually, the only court that I would posit that the only court that can consider the validity of this lien is the family law court, because it is an encumbrance of marital property that husband made.
Got it. So the civil, I'm not understanding. If it's in a civil court, if the family court is the court with jurisdiction to make the decision, why is it also in a civil court?
The civil court is to determine whether he can remain as trustee because he has breached his fiduciary duties as trustee.
That is not.
But that doesn't have anything to do with this.
That doesn't, but we have followed this court's instructions, because last time we were here and we tried to make arguments about the improper encumbrance of the marital property, they objected because we hadn't brought in the trust. We have since brought in Suleiman Hajmi in his capacity as trustee, who has done inappropriate and improper things with marital property under the family code. And the only person who can tell him that what he did was improper or order him to release this invalid lien is you, Judge.
That is not true, Judge. They have filed that lawsuit, not only trying to remove my client as the trustee, but they are also making claims that certain things that are owed to the trust, that he has acted wrongfully with the trust. That exactly goes to this deed of trust. And I will point out, Judge, it wasn't only signed by my client, it was signed by the wife as well. And what she's trying to do is take this money out of the trust, and the trust benefits her children. That is something that is before the civil court, and the civil court can make that determination whether this deed of trust was correct or not.
Is the civil case out of Dallas County?
Yes, Your
What is the cause number?
Honor. I can find that. Your Honor.
And Judge, I would point out that the trust has an attorney in that civil case.
So the civil case is wife filing the suit on behalf of the children against husband.
That is correct, Your Honor, and the goal of the trust case is to address Mr. Hashmi's actions moving forward. The goal of this case, this court, in addressing the lien on the marital property is a past transaction that occurred during the marriage. We are trying to ask this court to find that that past transaction was improper and there's been an improper encumbrance of marital property. And this court has to determine the propriety of that lien because it affects marital property. And again, it was a past transaction.
This is directly affecting the trust, and the trust is before the civil court. Judge, the trust has an attorney that they should have given notice to. They cannot affect the rights of their trust, Judge, without giving them proper notice, without giving notice to their attorney, and without giving them sufficient time to appear, respond, and get ready for trial. They waited to the very last minute, Judge, because all along has been the argument that the court needs to dissolve that deed of trust, keep the money in the community property, and divide it up between the parties. Actually, wife is asking that it all go to her. But in either case, Judge, that has been their argument all along, and they waited until after our exhibit conference, until after the pre-trial to do all of this.
And Judge, that's not correct because Ms. Rivera made this same objection in February. We were set to go to trial in February. I was instructed to amend my pleadings to give everybody proper notice, did so, served Mr. Hashmi. The return of service for him in his capacity as trustee was on file February 19th, 2026. Long past 45 days notice. They've had time to respond. We were then set to go to final trial on April 9th, 2026. And then we got reset to today. So they have had plenty of notice.
But at that point, Judge, the discovery period was closed. Because when we appeared at that hearing in February, the exhibit conference or the pre-trial, Judge Lee specifically told us that she was not reopening any discovery.
That is not correct, Judge. Actually, discovery remained open between February and April pre-trials. At the April pre-trial, I insisted that discovery remain closed between now and May 5th because with the resets that we have had, we've had to continuously supplement discovery. Judge Lee did not make a ruling that discovery was locked or closed until the April 2nd, 2026 pre-trial exhibit conference. And by the way, we were prepared to go to trial 3 months ago in February. We had all of our exhibits prepared, all of our exhibits filed, all of our pre-trial summaries filed. Opposing counsel did not have any of that prepared for the February trial date and actually had an opportunity to depose my client for 2 hours, a second deposition on her entire updated spreadsheet and inventory. So if there's any party here that has not had fairness applied to them, it is my client, Judge.
What I remember from the February was that it closed, Judge, that's what I remember. But in either case, Judge, the reason that I asked for a continuance on that day was because the wife's attorney got records from a year back before I even got involved in the case, and they didn't file any of those records until 14 days before trial. And I did not have any ability to answer or to do anything with those records at that point. Judge did allow us to take some depositions, Judge, but even if we go by the day session saying that the trust was served in February, at the end of February, their answer deadline would have been sometime in March. And then them coming to trial less than 30 days, I think is completely unfair to the trust.
And Judge,
We did get reset in April, but that still does not give them sufficient time to conduct discovery or even do anything in preparation of the trial. And they're asking to take $2 million away from the trust.
and Judge, first of all, they agreed to both of our trial dates, the April 9th, 2026 trial date and today's trial date.
I don't,
I have a question. Hold on one second. I have a question. Are you all asking to take $2 million? Are you asking me to take $2 million away from the trust today? Or are you just asking me to find that that a improper lien was placed on community property?
That one, and we're actually not asking to take anything away from this trust. If this trust wants to put that money in a registry of the court so no one can touch it until it's resolved, that's fine. All we are asking you to do is that he made invalid encumbrance under the Family Code 5.01.
Judge, they both made the encumbrance. But if they are telling you that they want you to find that it's an invalid lien, that negates whatever money this community property owes to the trust. They are essentially taking the 2 million from the trust.
And that is not true, Judge, because this court has the right and the ability to decide whether that encumbrance was proper in the first place. This whole $2 million is in dispute because we do not concede that that was a valid encumbrance.
They are
Under the
playing on
Family Code.
words, Judge. They are playing on words.
Okay, so the court is going to hear the testimony, consider the evidence, and give it its proper weight. All right. Okay, so prior to going on the record, there were some exhibits that were tendered to the court. I have wife's exhibits. Just make sure there. Okay, I see 1 through 12.
What?
Well, I'm breaking them. I don't see a 13.
Oh, yes, Your Honor, I did not provide the court with the ones that were excluded by Judge Lee or withdrawn by myself with the pretrial.
Okay,
So I'll go through my list. I'll follow along.
all right. So 1 through 12.
And Judge 7, 8, and 9 were withdrawn by me, so those should not be.
Okay. Well, I think it'll be easier if you tell me which ones were pre-admitted, and I will then admit those.
Would you like me to stand?
It doesn't matter. It's up to you.
1 through 6 were admitted. 7 through 9 were withdrawn by me.
No,
Just the ones that were pre-admitted.
10, 11, 12. 14 through 16. 18, 19. 21. 24 through 26. 29 through 38. 39, 40. 41 was withdrawn by me. Oh, sorry. 42. 43. 44. 45 through 49. 53. 54 is not an exhibit. Skipped. 55. 58 through 105. 107 through 137, Judge. At this time, I would admit those to evidence.
All right. Let me just go back through the transcript, make sure I wrote all of them down. Okay. So I have 1 through 6, 10 through 12, 14 through 16, 18, 19, 21, 24 through 26, 29 through 40, 42 through 44, 45 through 49, 53, 55, 58, 105, 107 through 137.
58 through 105.
58 through 105, sorry. So 55, 58 through 105, 107 through 137.
That is correct, Your Honor.
Okay, so all of those exhibits are admitted.
Thank you, Your Honor.
You're welcome. And then counsel, on yours, some of them are they have 2 exhibit 1s, 2 exhibit 3s.
I think it's just copied twice, Judge. It's
Oh.
the same thing.
Okay,
So it would be 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 through 19, 22, 26, 27, 28, 29, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 50 through 50, actually through 64. And then I have 65, and I think I skipped over 18, but that should be in there as well, Judge.
And 17, I didn't hear 17.
yeah, 17, I didn't include that one.
Oh, it's 16, 17.
Oh, I do see 17.
Yes.
There's no 18.
No. Oh, yes, there is. I'm sorry. There is an 18.
And Judge, 18 is actually a video recording of my client's deposition, so you might not see your file.
Okay. Let me see what else I'm missing. Okay. 40, 41, 50 through 64. And then is 65, or is 65 the summary of requested relief?
65 is actually a copy of the video of the second deposition, Judge. Can I number my requested relief as 66?
Yes.
And Judge, those were the same records, ma'am.
Okay. So I have 1 through 16, and then I have 16 through 19, 22, 26, 27, 28, 29, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 50 through 64, 65, and 66.
And 18? I think you did.
Yes, I said 16 through 19.
Yes, Judge.
All of those are admitted, and then let me go. Yes.
Wrong.
Let me see. I see a 34 on here.
And my records indicate that it was withdrawn, on force, I mean, both sides, but I'm not gonna fight about it.
I don't recall that, Judge. Actually, Ms. Gallus did the exhibit conference for me.
Let me go to. Intervenor, does intervenor have any
We
exhibits?
do, Your Honor. You're saying they've been sent to Judge Lee.
I see them now.
Okay.
Let me,
They, but for the second one, exhibit 29, they go through it one cohesive doc.
I see,
So scroll.
okay, I see it. Intervenor's trial exhibits. You just made it one large file.
That's just how.
Okay, no problem. So what we'll do is name it.
So exhibits 1 through 29 there. I don't. I have a binder if that's easier for the board.
Oh, no.
We'll just name it 1 and then.
We'll just name it. I see 28 exhibits in here.
Yes, Your Honor, and then there's a second email.
Oh,
So in-
okay.
In that that batch, there's just the 1 through 28, or not.
All right, so interveners exhibits is going to be one exhibit, but it contains 29 different exhibits inside.
Fair enough.
Got it.
And
They're all admitted.
I also have just an updated summary requested, which is isolated to our, this is what I've identified as the main version.
Okay,
30, and it nearly is a summary of what is the argument. That's
I have no objection, Your Honor.
thank you.
I don't really have any objection to their summary requested from the judge.
Okay,
Thank you.
so we're just naming this one 30.
Yes.
Okay. So 30 is admitted. All right. Okay, we've taken care of the exhibits. At this time, you all have 40 minutes aside that will include any opening and closing statements should you all choose to make one. It'll also include any examination of witnesses. Your exhibits are already in, so you can just refer to them as necessary. Counsel, would you like to make an opening statement at this time?
Save time, hopefully I have to close.
Okay, Attorney O'Vera? All right, is it Kirkham?
Kirkham, Your Honor.
Yes, Attorney Kirkham, would you like to make an opening? Okay, all right, and Rambo, am I saying that right? Okay, you may call your first witness.
Yeah.
All right,
Brief instructions for the witnesses that are all here. There's heavy stack of binders up there. I will refer the witness to the binders that I need them to look through if they're looking at it.
okay. Good morning. And just make sure you speak right into that microphone. And counsel, whenever you're ready, you may proceed.
And may I?
Yes.
Witness.
Yes.
Ms. Lopez, I'm just gonna help you turn to the two exhibits that I'm asking you about today. It's okay. They're found in
Her name, counsel?
Ms. Lopez. First,
Sharon Lopez. Please state your name for the record.
Sharon Lopez,
Okay, and Sharon, for what role were you appointed in this case?
child custody evaluator.
Okay, you've got in front of you, wife's exhibit 15. Were you provided with a copy of the order for custody evaluation in this case?
Yes,
Okay. Can you just briefly tell this court, well, did a custody evaluation happen in this case?
no,
Can you briefly tell this court what happened with that?
I received the order in June, late June, early July of 2025. And Ms. Hashmi contacted me and paid her part of the retainer. And I provided initial paperwork to her. Approximately a week after that, I spoke with Mr. Hashmi, gave him the same information. And he never remitted payment or completed any paperwork.
And how much did you charge Ms. Tajmi for her half of the custody evaluation?
$4,000,
And in fact, is part of that payment covering your appearance at today's hearing?
it is.
So it's who of the two parties, husband and wife, who cooperated with you regarding the custody evaluation?
The wife, Ms. Hashmi.
Nothing further.
all right. Attorney O'Vera?
Did you have any contact with my office?
Only through email.
Okay, and it was explained to you that my client didn't have the money for the funds to pay you, correct?
Correct.
Now, ma'am, do you recall when that contact was?
I believe that was in August or September.
So how much do you charge for the court appearance?
Half day retainer is $1,400.
So if 1,400 is for today's appearance, is she eligible for any kind of refund for what she paid you?
Yes.
I'll pass the witness, Judge.
All right. Attorney Kirkham?
No questions, sir.
All right. Attorney Rambo, any further questions from this witness?
How much did you ask Suleiman to pay for the custody evaluation?
Also initial retainer, 4,000.
That's it, Your Honor.
All right, may this witness be excused?
Yes, Your Honor.
Thank you. You may call your next witness.
May I come out to the hallway and get Janie English?
Sure.
I would call Janie English, the children's therapist.
Okay, thank you. Would you spell her first name for me?
Janie
Thank you.
English.
Just speak right into that microphone. Bring it close to you.
Can you state your name for the record?
Janie English.
And what is your role with the children involved in this case?
I'm an LPC, I'm their treating therapist.
When you say there, which children are you treating?
Isla, Ashmi, and Sasha.
And how old is Isla?
She is 10 now,
And how old is Sasha?
8.
And ma'am, we've got a lot of paper up here, so I'm directing you to wife's exhibit 130 and 131 that are already in evidence. Is exhibit 130 a true and correct copy of your CV?
Yes.
And is exhibit 131 a true and correct copy of your therapy notes through March 2026?
Looks to be yes.
And I understand that the text is kind of blurry, so I'm gonna ask you to work with me there. But you've got these notes in front of you, please read them.
Okay.
And can you tell this court what precipitated, or what led to you getting involved as Isla and Sasha's therapist?
The children first came to me for therapy to help manage emotions related to sexual molestation. Excuse me, by their grandfather.
Okay, and are you qualified to work with children who are dealing with circumstances like that?
And
What training do you have specifically as it relates to sexual molestation?
I am a licensed LPC in Texas. I have training through ITCT complex trauma. I also focus my required supplemental training through the state on complex trauma, child abuse, and neglect.
How long have you been working with Isla and Sasha approximately?
I think they first came in early 25.
And have you come to know both of these children in your work?
Yes.
If you had to summarize in 1 or 2 sentences for this court, what your concerns are as it relates to both children, what would that be?
What my concerns are for both the children right now,
Yes.
that they feel.
I'm not object to multifarious.
Judge, I asked what her concerns.
She asked, what concerns are for both children right now?
Just passing the sheet. Exactly. Certain for each child.
Oh, for each child. Okay, rephrase.
Can you tell this court what specific concerns you have as we sit here today for Sasha?
Well, my concerns for Sasha are her concerns that she does not feel emotionally safe when she's with her father, that she does not feel believed in her reporting of the sexual molestation, and that she is often afraid of retaliation from her dad and her sister.
And who does she report sexual molestation at her time?
Her paternal grandfather.
And what does she report happened?
she reports that she slept with between the grandparents, as many kids do, and that her grandfather was rubbing and, pressing hard on her, as she calls it, her tissue.
Her what?
Genitals.
Her
The children's word for her vagina is pishy. I'm gonna guess PISCHI. I think that's how I spell it in my notes.
Okay, and as far as this report to you, do you believe it, Sasha?
I do.
Right, and you mentioned a few minutes ago concerns about not being believed by her father and her sister. Which sister? Can you name her, please?
Selena is her she's
And to your understanding, that's the adult child of the clients?
yes.
Eating judge.
Sustain, don't lead.
Who is Lien Hashmi to Isla, Sasha?
Their older sister.
Let's talk about your concerns as we sit here today for Isla. What concerns do you have for Isla?
The same concerns that she has anxiety related to the incident itself and to not being believed by the father and to feeling that she's been being put in situations to interact with the grandfather that caused her to be different.
And can you tell this court, in your experience, what the long-term impacts of not being believed by a parent has on a child?
Oh, well, there are a number of long-term effects. Not being believed, and in this case, not being believed by a person who a child counts on to keep them safe, a parent, sends the message that speaking up is dangerous. It sends the message that abuse is something to be tolerated in silence. It sends the message that her story is not important, or her truth is not important or is false. Now, when we look at the long-term impacts of kids in these kind of situations where they're not believed, we see a greater incidence of anxiety, depression, self-harm in later years, difficulty interacting with persons of authority, and difficulty with adult relationships.
Do you believe that Isla is at risk for that? And then into adulthood, if her father continues not to be her?
Judgment to the lead, speculation.
Sustain is to leading.
What do you believe about the implications this can have on Isla into adolescence?
I believe that she is at risk for greater anxiety and depression as she grows up.
And as for Sasha, the same
The
question.
same, I believe that Sasha also is at risk for anxiety, for depression, for acting out behaviors, for difficulty trusting adults.
Can you tell this court what you diagnosed Isla with?
She's diagnosed with post-traumatic stress disorder, which is related to the incident itself, the initial incident and the ongoing emotional impact of that. She's also diagnosed with an adjustment disorder and anxiety, which has to do with the situational anxiety that she experiences, the ongoing stressors of not being believed and the stresses in the family dynamic at present. And then she is a cousin in the child sexual abuse.
And then as far as Sasha's diagnoses,
They're the same.
what do you recommend for these children going forward as it relates to their grandmother?
Say that.
Is it safe for these children to be around their paternal grandmother?
I do not believe it is safe for the children to be around their paternal grandfather,
Physically safe?
physically or emotionally safe.
Okay. As far as, have the children reported to you that they've been around, paternal grandfather recently?
Yes.
Judge.
Hold on, let me look at the question. The children reported to overrule.
You can answer, and I can ask the question again.
At their last objection.
Non-responsive.
You haven't even started answering, Judge.
So the question was, have the children reported to you that they've been around paternal grandfather recently?
Yes,
Okay.
When and when?
at their, session at the end of March, the children reported that they were at an Eid celebration.
They were an Eid celebration?
An Eid, EID, it's the celebration at the end of Ramadan. They were at an Eid celebration in which, their sister Selena pushed them in the back and told them they had to go and hug their friend.
And is this just one example of many reports the children have made about their sister pressuring them to be around family?
Objection to leave.
Sustained on lead.
What cultural, these children are multicultural, correct?
They,
And have the children expressed anything to you about their culture?
well, they're very proud of their culture. I love, especially kind of recently as kind of learning more about holy prayers and those things that are important. The culture is important.
Have either of the children reported anything to you about what their father has said about their culture?
With regard to therapy,
Yes.
well, they report that their father tells them, I am not a good counselor for them because I don't understand their culture. Well, wait a minute, white people don't understand our culture was an exact statement.
And how long have you been working with these children again, roughly?
Over a year.
You're happy to continue doing so, correct? You're happy to continue doing so?
I'm happy to continue to.
Which, which parent do you speak with primarily?
I chat with their mom for a couple of minutes at the end of each session.
His father reached out to you to discuss the girls. Nothing further, Your Honor.
All right, Attorney Elvira Cross.
So Miss English, have you reached out to the dad to talk to him about the situation?
No,
Have you gotten any kind of information with it lead you to believe that the kids are in some kind of harm or danger if you got to report it to CPS? Is he yes or no, ma'am?
say the question
Okay, let me rephrase it. You are a mandatory reporter, correct?
again.
And I'm gonna assume that in your sessions, if you're getting any information from the kids that make you think that he's hurting them or harming them, you're gonna report it to CPS, correct?
If it's immediate physical harm, yes.
Have you had to make any reports to CPS regarding my client? Now, you've been seeing him for about a year, correct?
Yeah.
And in some of your notes, ma'am, the children are referring to specific things that are going on in the court, correct? Yes or no, ma'am?
Yes.
So they're getting a lot of information from one party or another regarding the proceedings in court, correct?
Correct.
Do you think that that's appropriate?
That depends.
Do you think it's appropriate to share with a 10-year-old and an 8-year-old what is going on in court?
No,
Do you think that it's appropriate for somebody to share with a 10 and an 8-year-old that daddy is mad at you?
their dad told them that. They should.
I didn't ask you that, ma'am.
Do I think it's appropriate for them to share that their dad is mad at me?
Yes,
It's to me in therapy?
yes.
So, I'm like,
Okay, do you think it's appropriate if mom is sharing that type of information about the things that are said in court?
Objection calls for speculation.
Sustained, rephrased.
Hypothetically, ma'am, if one of the parents is sharing with the kids what is coming out in the court, do you think that's appropriate?
if one of the parents is, it's not appropriate.
Now, ma'am, you understand that the allegations are against his dad and not him, correct?
The allegations of sexual abuse?
Yes.
Yes.
Okay, so ma'am, do you understand, well, let me rephrase. When kids come to you for counseling, ma'am, you take their statements as true, correct? That's a yes or no, ma'am.
Yes.
You're not out there investigating whether it's true or not, correct?
Correct.
Did you get provided the CPS records?
Yeah, I believe we did that. It was in my office.
Do you find it odd at all, ma'am, that initially the child, Sasha, had reported to CPS that Selena was her safe person?
Do I find that? What?
Do you find it odd?
No,
Because today you're saying that Selena is putting a lot of pressure on both kids.
yes,
And you're saying that dad is putting a lot of pressure on both kids.
the children report that he is.
How do you know it's not mom putting him up to report that?
Do you want my whole answer? Because I'm pretty sure we've been through this before. I am not a forensic evaluator. My role as the children's therapist is to meet them with their clinical presentation each and every time they come in. The children are consistent with their story, their language is developmentally appropriate,
Non-responsive?
well,
Judge,
you
you
asked.
open the door to this.
So she responded to my question already.
You may ask your next question.
So that's exactly what I'm saying, ma'am. You are not gonna investigate, you're just gonna take what the kids report to you as true. Correct? And they've actually reported to you that they've had good times at dad's house, correct?
That they've had what?
Good times at dad's house since all of this came out. They've actually reported to you that the visitation is getting better, correct?
Until recently, they have in the past reported, but in their most recent sessions, they do not do that.
So now, right before we come to court, now all of a sudden the problems have emerged again.
Objection,
Is
Patrick.
that correct?
Overrule.
Is that correct, ma'am?
It is correct that in recent, sessions, there have been events that
I'm
happen.
gonna object as non-responsive. That's a yes or no question.
Sustain.
You need to say, you're wanting me to say they're changing their story simply because.
Objection to non-responsive. There is no question before the witness.
Okay, then the answer to the question is no.
Can I proceed, Judge?
Yes.
Okay, so ma'am, those allegations of the sexual abuse are against his father. There have been no new allegations of sexual abuse, correct?
Objection, compound. She asked 2 questions.
I'll break it down. There
Sustain.
have been no new allegations of sexual abuse, correct?
Hmm.
And ma'am, if you know, did any criminal charges get filed against the grandfather?
I don't know.
If you know, ma'am, was there anything else done by either criminal prosecution or CPS regarding these allegations?
I don't know.
I'll pass the witness, Judge.
Attorney Kirkham.
No.
Yes, Your Honor. Miss English, Janie. In your line of work, is there a difference between physical and emotional abuse?
Yes,
Who is the physical abuser of these children?
they report their grandfathers.
Do the children report any emotional abusers in their life?
They do.
Who?
Their father and their older sister.
In a few sentences, what does Sasha report about the emotional abuse by her sister and father?
She reports that they tell her it is her fault, that there's an estrangement with the grandfather. They tell her that it is her fault that she is not allowed to see her paternal cousins. They tell her that it's her fault that her dad is angry.
What about Isla?
As she reports the same, that she and her sister are told that everything is their fault.
Have the children reported any derogatory remarks by father about their mother?
Objection to this meeting, Judge.
Sustain. Rephrase.
Can you tell this court what the children, if anything, have reported that their father has said about their mother?
Yes, they frequently report that their dad says their mother is brainwashing them. They reported an incident, I don't think the last session, maybe the session before, in which their mom had fallen asleep and not answered the bell when they first rang it and were brought back, and the children expressed that they were worried about their mom. And that their dad turned to Selena and said, "When they no wishes come true."
What wish was that?
They interpreted that to mean
That is.
Hold on one second. Go ahead,
The speculation, Judge.
sustain.
What did the children interpret?
the children
That's
interpret-
again, Judge is calling for speculation if she's asking what the kids interpret it as.
Sustain, rephrase.
What did the children think of that statement by them?
the
Judge,
children
I'm
reported.
gonna object again if she's asking them about what the kids interpret or thought about it. That's speculation.
Sustain.
Let's talk about events that have happened recently. You were asked a few minutes ago about what has changed recently with the children's position regarding their father's health. You remember that?
Mhm.
Can you tell us more briefly what events recently have shifted the children's desire to spend more time with father?
Each episode,
I'm gonna object, that assumes that's not in evidence.
And Your Honor, opposing counsel opened the door to this when she asked what the children's perspective was on going to father's house recently. And then asked her whether it was implied that it was convenient that the children's tune was changing with his child.
I didn't ask.
The question was, can you tell this court briefly what events recently have shifted the children's desire to spend more time with father?
I can rephrase the question.
Yes.
What if the children reported to you recently about the children's relationship with their father?
they reported recently that they were frustrated that their dad did not keep them safe at the Eid festival, that their dad required them to create a Eid card for their grandfather, which they did not want to do. And that their dad told them he was going to fix it where they would spend more time with him and spend the night, which they no longer felt safe to.
In a few sentences, what ongoing harm do these two children face if they continue being treated in this manner by their father?
Well, they feel invalidated by their father. They feel that their truth is not important. Attachment is biological, right? The children love their father. But trust and safety are experiential, right? Sometimes with kids, attachment overrides safety, but the kids do not feel safe with their dad most of the time, especially when incidents happen that they feel are not creating the boundaries they need with them.
Who, out of mother and father, who did the children feel safest, report that they feel safest?
They report that they feel safest with them.
Nothing further.
All right, anything further?
Prior to the Eid celebration, ma'am, how many times have the kids reported to you that they ran into their grandfather?
Prior to the Eid celebration at one other, religious event.
So in the whole year that you've been treating them, they've talked about 2 events where they have ran into their grandfather.
No, I think there was probably another one earlier too, because as a family gathering or something where they saw him across the room, not where they were pushed to go hunting.
Okay, and you don't know anything about the circumstances and why they ended up in the same place, correct?
Correct.
And was this Eid celebration at their mosque or somewhere else?
It was, it was after prayers, so I'm not really sure how that works exactly.
Okay, so it could have been in a public place that maybe they just ran into that granddad.
No,
No?
they report that they had come out, I'm gonna say it was at the mosque, yeah, because they had come out of the prayer event.
Okay, so the mosque is a public place, correct? Well, if somebody wants to go to the mosque, do you assume that they can go?
I assume you can.
Or pass the witness, Judge?
Okay,
No question.
all right. Ma'am, I have a question for you.
Yes, ma'am.
In regards to the children speaking to you about what's going on in court, could you give me some specific examples?
Uh, yeah, that was her question. I mean, I don't know, the children aren't speaking about what goes on in court. They're, like they said, our dad told us we were going to get to, he was going to fix it where we could spend more time with it, right? They talk more about, it's more about the visitation dynamics itself than something they specifically heard went on in court.
So in regards to the visitation component itself, what are the girls specifically saying about visits with dad? Like, do they even want to go?
They don't want, well, here again, they want to spend time with their dad, but I will tell you, Judge, if you listen to these very, very bright and emotionally intelligent young girls, it's more about, they want to see their cousins, to be honest. And they feel like they've been ostracized from the paternal family, right? And told that it's their fault and they want to see their cousins. They also want to spend time with their dad, but they say they do not feel safe with their dad. Isla's statement to me was, I think my dad has FOMO. He is always going out to parties and leaving us alone. And our brother doesn't like babysitting us, right? So they want to come back to their home with their mom at night, where they have their pillow and they have their stuffies and they know mom's not going anywhere. It's not saying they don't love their father or want to be with them, but they don't want to have overnights. And can I say one more thing, Judge?
Yes,
While
ma'am.
you guys,
Yes, ma'am.
ethically, this question about asking me if I reached out to fathers, emotionally, the kids feel their dad is the offending parent, right? So it would not even be ethical for me as a treating therapist. Remember, I'm not a forensic evaluator. It would not be ethical for me as a treating therapist where I'm supposed to create the safe space for these girls to tell their story, their truth. For me to say, well, let's see what the grown-ups have to say about this. It's, as a therapeutic counselor, it's not even ethical.
Thank you for that.
Yes, ma'am.
In regards to them saying they did not want to have overnights with dad, did they give you any additional information as to why they felt like that, or they just left it at, I don't want to have overnights with dad?
Oh, they give me quite a bit.
What are some things that they say?
It ranges from everything that dad never turns on the heat or the air and the house is too cold or too hot, to the fact that their dad leaves them a lot at night, to the fact that they don't feel that he is, they can trust him to keep them safe from grandfather. And sure, does it seem like they've extrapolated that out from the specific events where they have been forced to see him? Sure. But this is we're talking about children's minds and the conclusions that they draw about their own personal safety.
To your knowledge, based on what the girls have reported to you, have they reported being left alone with grandfather while dad is out?
No.
Okay. All right. Well, thank you very much.
Thank you.
May this witness be excused? Go ahead.
Do you recall in your notes, ma'am, you made some commentaries about when dad gets arrested? That's a yes or a no?
Yeah, and one last year, I think they said something about that.
So obviously my client is in jail, that has to come from mom, correct?
I'm not gonna make that assumption.
Well, they're the two that have the rights of possession, correct?
Correct.
You say that the kids were forced to see their grandfather? Is that what you
Their
said?
perspective, they were forced.
If you don't have any information today that Mr. Hashmi personally took these kids to their grandfather to see their grandfather.
Their report was that their sister pushed them in
Listen
the
to my
back.
question, ma'am. I'm not asking you about the sister. do you have any information today that would lead you to believe that Mr. Hashmi has taken them physically to their granddads and forced them to be with their granddad?
To their grandfather's home? No.
I'll pass the witness.
Judge, may I ask the witness one more question?
Yes.
Is it possible someone other than mother or father could have told these children that their dad was in jail?
Yes.
That's it.
Oh. All right, may this witness be excused.
Yes.
Thank you so much.
Thank you.
Counsel, you may call your next witness.
Ms. Judge, may I get a time check?
Sure. I'll start with Attorney Kirkham. He has the most amount of time. He has the full 40 minutes. Attorney Rambo, you have 24 minutes and 17 seconds. Attorney O'Vera, you have 30 minutes and 59 seconds. Yes, ma'am. Yes, ma'am. You're welcome. Have a good day. Thank you.
Judge, I would call Marjan Hajmi to the stand.
Okay. Ms. Hajmi, just make sure you pull the microphone close to your mouth. I know you speak softly.
Is that okay?
Yes. And whenever you're ready, counsel, you may proceed.
Yes, Judge, I believe it's an evidence, but just as a precaution, I would ask this court to take judicial notice of wife's fourth amended petition for divorce with this court.
The court takes judicial notice of all contents of the court's file.
Thank you, Your Honor. Ms. Hajmi, please state your name for the record.
Marjan Hashmi,
And you're the mother of how many children with Suleiman Hashmi?
4.
Okay, and briefly, the 3 minor children that are still before this court, what are their names and what are their ages?
Isa is 15, Isla is 10, and Sasha is 8.
Okay, and Isa is a boy, right?
Yes,
And Isla and Sasha are girls?
yes,
Throughout my testimony today, you might hear me refer to the girls. I'm referring to Isla and Sasha.
okay,
Only the girls see Janie English for therapy, correct?
yes.
As far as Isa is concerned, do you have the same concerns for Isa as you do for your daughters?
No,
You are asking this court for divorce today, correct?
yes.
Around when did you first file for divorce?
I think it was September of 2023,
So how long has this case been going on?
almost 3 years.
Are you ready to be divorced, ma'am?
Yes.
And what prompted you to file for divorce?
It was Suleiman's behavior, bankruptcy, a lot of different things started to happen.
You mentioned the bankruptcy. Around what period of time did these things start?
Throughout the bankruptcy, the way Suleiman was started getting angry and, the way he was at home and the issues it was causing, it would worry me, and then I would hear different things throughout the bankruptcy, and it made me realize that Suleiman wasn't honest, he wasn't the type of person that I thought he was.
Before these cracks started to appear in your relationship with Mr. Cosby, how were finances handled by you and your husband during marriage?
Suleiman would make all financial decisions for us. I always stayed at home and took care of the kids when he worked.
And is that something you were okay with?
Yes,
And how has that changed recently?
recently, during the bankruptcy, I tried to help and started working when Sasha went to kindergarten, because I had from like 8 to 2:45 before carpool, so I went into work and tried to help out, and I got a part-time job, and then he accused me of having an affair because according to him, I am a college dropout, so no one would hire me. And that's when I decided I wanted to have a divorce.
Does that pretty accurately describe how you were treated towards the end of your marriage?
Yes,
And how does that make you feel?
Or, I'm okay, you know,
What steps have you taken? You said you don't have a college degree, correct?
no, I don't,
Are you employed right now?
yes.
How many jobs do you have?
I have a job, one job, and I have a business that I started.
Okay, let's tell the court briefly what you do for your formal job, and we'll talk about your business.
Yeah, so I am part of a construction company and I do project management on different projects. I help design, work with architects, civil engineers, I pick materials, colors, anything from start to finish on a construction project.
Okay, and what is your personal business?
My personal business is also, it's a consulting business for designing.
Let's talk about some of the financial issues your family has had. Can you really tell the court when did you purchase the marital residence?
In 2016,
And how did you guys pay for the marital residence?
we bought it cash.
So the house is owned outright, correct?
Yes,
About how much do you remember paying for the house at that time?
it was like close to $2.5 million.
How much is the house worth today?
About 4.5
4.5 million.
million, yes.
Who lives in the house right now?
Me and Sasha and Isa.
Do you know, is the house insured?
No,
Tell the court why that concerns you.
because if something were to happen to possibly we lose all the value of it.
Is it safe to say that the house is one of your biggest marital assets?
Yes.
Let's talk briefly, well, you're aware that what's already in evidence is the property spreadsheet from April, correct?
Yes.
We had an opportunity to review that.
Yeah.
And we also had an opportunity to review your requested relief, correct?
Yes.
The requested relief that the court has from April asks the court what you want done with the children, correct?
Yes.
Okay. Are you asking this court today that you be appointed sole managing conservator of children?
Yes.
Why?
Because I already do everything for the children.
Like what?
And everything to bring them to bed, to making sure they're okay, they're fed, they're taken care of. Clothed, activities, school, lunch, breakfast, everything.
Who handled, up until the divorce, who handled doctor's appointments for the children?
I
Who handled dentist appointments for the children?
did.
Who handled educational decisions for the children?
I did.
Has that continued throughout the pendency of the divorce?
Yes.
This dad stepped up a little bit since the divorce was filed.
Objection to the leading judge.
I'll withdraw the question, Your Honor.
Okay.
Can you tell us for why you're asking for exclusive medical decision making of the children?
Yes, because I think that is the safe thing and the best thing for the children's health.
Is there any specific incident that comes to mind that would also lead you to take that position?
Yes.
Tell the court what that specific incident was.
When Selena was a senior in high school, she complained of having chest pain, and Suleiman decided to drive her all the way to Paris, Texas, which is almost like 2 hours away because his uncle is a cardiologist over there. And I got really upset when I found out because it's super dangerous if a child complaining of chest pain, you should drive to the closest emergency or hospital. And he chose for his convenience to drive there. So I don't trust him with those decisions.
What is the current possession schedule you and your husband have of?
It's 2255.
He suspends overnights with that, correct?
Yes.
What is the current possession schedule that you have with Isla and Sasha?
It's the same 2255, but they come home every night at 8 p.m. And when it's his days of possessions, he picks them up at 8 a.m.
Who has 100% of the overnights with girls?
I do.
If this court were to look at your exhibits 1 and 2, do those exhibits accurately depict, at least as of April of 2026, what you're asking the court to do with your children and your property?
Yes.
Who was ordered by this court to be child support?
Suleiman.
Are you aware of the current status of how much child support you owed?
I don't know the exact number.
There are exhibits and evidence that reflect that at least as of December of 2025, you were owed about $11,000, correct?
Sustained on lead.
To your knowledge, are you owed an arrearage for child support?
Yes,
Who carries the children on insurance?
I do.
Who ensures that they have insurance?
I do.
That's also an evidence, correct?
Yes.
Where does your family reside for the most part of the time?
In Atlanta, Georgia.
Where does Mr. Hajmi's family reside?
In Dallas.
Tell us more briefly about that family dynamic in the early years of marriage with Mr. Hajmi's family.
We would do everything with this. Suleiman's Hashmi. Suleiman's family was close and we lived at his house for the majority of our marriage in the beginning and till 2016. And I lived with him and I took care of his parents when they were sick. I took care of everybody, raised my children in his parents' home. They were all very close, but also controlling.
How so?
I mean, to the point where his mom would ask me who my friends were and who she liked and didn't like, to how to raise the children. I would try never to ask them to help, other than a few hours here and there. I wouldn't leave my children. I slept with my kids every night till this day. My 3 children sleep in my room. He says a little too big to sleep in my bed. So I've got him a frame and a mattress attached to my bed on the foot side, so he says sleeps horizontally with me. I let Sasha sleep on my bed to this day. So my kids are close to me. I've always slept with them, taken care of them, put them to bed, showered them before bed.
Do you like being home?
Yes,
At the end of the day, would you like your children to be closer to your family?
yes, I've never been able to take my children for a single birthday event, Eid, or holiday, or anything to my parents because Suleiman and his families would not let me. I always had to be in laws.
That leads me to another question. Has travel been an issue for you? Tell this divorce has been pending.
Yes.
Tell the court about what happened with the recent travel issue.
So after Suleiman was left from the house, I was told by my other attorney, previous attorney, that I would have to have a notarized document to travel outside the country. And it was my cousin's wedding. I had notified Suleiman weeks before, months before, told him, asked him for permission. He had said yes. I had sent him over the documents to notarize. The kids practice dances with all my cousin's children that are the same age on FaceTime, WhatsApp. Sasha was a flower girl. We had this planned for months. We were going to Jamaica for my cousin's wedding, and the day of the wedding, or the day we were leaving, which was Halloween, October 31st. I get to the airport and Suleiman had not given me the document after I asked for it, and we were almost missed our flight. They would not let us board, and I had to show them all kinds of paperwork to prove I was allowed to take them a text message and everything, but that's happened before, and they were all crying at the airport because they almost thought.
Are you asking this court to do what's
Hold on 1 second. What was your objection?
Do they hear saying the kids? She was gonna go into what the kids were saying.
she did, Your Honor?
She said, and they were all crying at the airport because they almost missed their flight. That's where she stopped. Overall.
Are you asking this court to put some provisions in place to make it easier for you to travel with the children?
Yes,
But are you also asking this court to put some protections in place requiring Suleiman to comply with travel notice provisions?
yes.
And can you tell this court why you have some concerns about Suleiman's ability to comply with the court order?
Because he has not complied with previous court orders in this court or in other courts,
What other courts?
and the bankruptcy court.
What happened in the bankruptcy court when Mr. Hajmi didn't comply?
He was held in contempt and put in jail.
And there's documents and evidence that reflect that, correct?
Yes,
Has he ever been held in contempt by this court?
yes,
Even if this court tells Mr. Hodgman to do something, do you believe he'll comply with it? You've been married for how long, man?
for a while, it was been 20 years.
Safe to say, you know, Mr. Hodgman's gonna go off, correct?
Yes,
Let's talk about your family briefly. Would you like the ability to reside closer to your family
yes,
and remind this court where they live?
in Atlanta, Georgia.
You're aware that there's some pretty strong laws in Texas that make it hard to do that, correct?
Yes,
Do you feel that your children and your life is kind of an exception to some of those harsh requirements against moving past Texas?
yes,
Can you tell the court why you would be able to ensure that Mr. Hodgman has an ongoing relationship with these children if you are allowed to live in Atlanta?
he could come anytime. I can get him a ticket. If he doesn't work, he doesn't. Yeah, I can, there are ways that you could spend time with the kids, so.
Do you have any job opportunities in Atlanta?
Yes, I do.
Tell the court briefly about that opportunity.
I was offered a position to be a lead developer for a company. And I would be able to do all their land developments, and I would be able to have a flexibility with the kids' schools, timings. I would get benefits plus almost up, I think more than almost double my salary right now.
And what plans do you have for the children if you are permitted to move to Atlanta?
My plans are to provide them with, live close to my family. My brother and my mom and dad live across the street from each other. The school districts are great. I grew up there. I went to the same school districts. They would be close to a lot of immediate family, plus a lot of my cousins and aunts and uncles who live there, who also, Island, South Shore, and East all have cousins.
What steps have you taken to ensure that their psychological care will continue?
I have discussed it with Jamie. She would be able to offer telehealth, as well as there are some very qualified therapists there, and they would also make some recommendations, Sunrise Council.
Would the telehealth be temporary during a transition?
Yes, so the kids don't have any lack of therapy.
Let's talk very quickly about some of the property issues in this case.
Okay,
How would you describe your family's property situation in a couple words right now, as we sit here today?
currently, it's a mess.
Why is it a mess, man?
I don't know what Suleiman has done with finances, with anything. It's been hard to figure things out.
Has it been hard on you financially?
Yes,
How have you made ends meet? Give the court a few examples.
I've worked a lot. I try to do as much as I can, but still being there when the kids are home, and then when they go to bed, I work again. And then my dad has helped me a lot. He pays for my training fees.
For the most part.
Yes,
Briefly, you heard some discussion before we started today about a lien on your residence.
yes,
Can you tell this court whether you believe this lien is valid?
I don't believe the dollars.
You're aware that documented evidence shows that your signature is on this lien, correct?
Yes,
Can you explain to the court why you don't believe that that is sufficient evidence of your consent?
yes, I would sign everything for Suleiman before leading up to the bankruptcy blindly. He would ask me to sign things, and I would. Often he sent me a last page on the email while I've been at work and saying, sign this and fax it back, so. I don't read the documents, and a few times I did ask him, he has insulted me in front of the children, asked me never to question.
At this point, it's not responsive.
Sustain. You may ask your next question.
Until recently, you trusted your husband?
Yes,
What has come to light over the past several years that makes that opinion that your husband change?
all the documents that you see of all the different liens and with the cars that were faked, with this property lien, there's been a lot of evidence.
Out of this mess you described earlier, in this property situation, who has attempted to clean up that mess?
I have,
What are a few things you've done to try to make things better in the 3 years this case has been pending?
I reached out to the homeowners association. I caught up on all the property, HOA dues that were left. I went to meet with the attorney there. I was in contact often with the attorney for the Dallas County property taxes. I tried to pay while Suleiman was ordered to return the cars. And him and his friend put the liens on them during that whole case. I would make as much, they recommended making a payment, so I would make a few $1,000 payment every month to property tax to the house when they get foreclosed. Then finally, after 10 months, when he did sign over the power of attorney, Suleiman, I was able to sell the cars, pay the property taxes.
And man, we've done all this without a college degree, right?
Yes,
You learned a lot in the last 3 years, right?
yes,
Judge, how many people leaving, Judge?
Sustain, don't lead.
Ma'am, do your pleadings accurately reflect what you're asking this court for as it relates to your children?
yes,
Do you believe everything you're asking this court for is in the children's best interest?
yes,
And do you agree with most of Jane, with all of Jane English's testimony about the children and her concerns?
yes,
Do you have this, share the same concerns as Ms. English?
yes, very much so.
Do you believe that your proposed property division is a just and right division of the community estate?
Yes,
Nothing further, Your Honor.
All right, you have 4 minutes and 10 seconds left. Attorney O'Vera?
So then, you're asking this court to set aside the deed of trust that's owed to the Innocent Age Trust, correct?
it's not owed to the trust.
Well, the deed of trust says that the principal amount owed is 2.5 million, and that's supposed to be paid to the trust, correct?
That's what it says.
And simply because, according to you, you don't remember signing it. Is that correct?
Yes,
Now, ma'am, you and your husband did a lot of these dealings together, correct?
no,
You were listed on some of the paperwork for the companies. Do you recall that?
no,
You don't recall that. Do you remember filling out paperwork with your husband for the bankruptcy court?
I did not fill out the paperwork. I did sign it.
You signed it. You participated in hearings, correct?
Some,
Well, the ones that I have from 2022 that were done on the phone, you were on the phone with them, weren't you?
yes,
And in those hearings, ma'am, there was a lot of discussions about the jewelry, about the Dubai property, about the Dubai accounts, correct?
no,
Ma'am, I'm gonna refer you. Judge, can I use the screen?
Sure. Is your laptop connected?
It is.
Okay, so. You should be able to now. Chris, would you pull the projector screen down? There it goes.
So I'm gonna go back just a little bit, ma'am. You and your husband filed for bankruptcy in the year 2021, correct?
yes,
And in that bankruptcy, it was a chapter 7 bankruptcy, correct? If you recall.
I think so, yes,
And the chapter 7 bankruptcy, ma'am, is a liquidation of your assets to pay off bills, correct?
I'm not sure what the difference of those chapters is.
So ma'am, you're running a business today, you're working, you're saying you've done all of these things. Would you agree with me that you have some knowledge of the things that are going on?
Yes,
Okay, so in 2021, you filed for bankruptcy, it is in liquidation. And you're supposed to liquidate your property to pay off debt, correct?
yes,
Do you remember in 2021 how much debt you and your husband had?
no,
Okay, would it be correct to say that it was in the millions?
Yes,
Now, part of the bankruptcy, ma'am, is that they sold off some property and they dispersed it between the creditors, correct?
I'm not sure what properties.
Do you recall, ma'am? Your exhibit 90 shows that 2.8 million was collected and 2.2 million was distributed to creditors. Does that sound right?
Yes,
And about 565,000 went to the administrative cost of the bankruptcy proceeding, correct?
this from the settlement of the bankruptcy.
I'm talking about your exhibit number 90 now. Now, in your exhibit number 90, it also shows that the company called Healthsite was worth 3.75 million. Do you recall that?
Yes,
And I'm gonna assume, ma'am, and you can correct me if I'm wrong, from your property division that you proposed to the court, that's where you're getting the 3.75 million, correct?
yes.
But that company closed down in 2022, correct?
I don't know when it was.
Ma'am, the exhibits, if they are before the court that show that that company was forfeited in 2022, you don't have any reason to doubt that, correct?
I don't trust him, so no, I don't know.
The exhibits are already admitted into court. Do you understand that?
Yes,
And the exhibits show that that company ceased to exist in 2022, correct?
yes,
And you remember that there was a telephone call, a hearing that was transcribed, and I've given you copies of those exhibits as well, where you're talking about health sites and all of the property and assets health sites have. Do you recall that?
there is a transcription, but I don't know if I recall I speaking about it, but Solomon does.
So you heard your husband speaking about it and about all of that medical equipment, basically, that was owned by health sites, correct?
Yes,
And the bankruptcy trustee took all of it, correct?
yes,
So there is no 3.75 million of health sites anymore, correct?
I don't know.
Okay, so if it's shown in the records that you have provided to the court, you don't have any reason to doubt that, correct?
Yes,
Now, in 2022, there is a transcript that talks about the Dubai real property and the Dubai bank account.
yes,
And that was also a telephonic hearing where you and your husband participated, correct? And there, he tells the bankruptcy court that there were some accounts and there was an apartment also in Dubai that were owned by the trust. Correct?
yes,
Now, ma'am, later on, after you separated sometime in 2023, correct?
separated, living together.
Okay, well, let me rephrase. You filed for divorce in 2023.
Yes,
He leaves the home early part of 24, correct?
yes,
And I believe your story that you told me in your deposition is that shortly after he leaves, you discover records about the accounts in Dubai and the property in Dubai.
no,
Ma'am, it's in your deposition that the court has in front of it already.
yes, it was when he was out of town, when he took the kids to Dubai, is when I found the title deed.
That was in 2024, correct?
No, he went in October fall break when the kids had a week off in 2022.
In 2023. So if your deposition shows something different, ma'am, how do you explain the difference?
I don't know what the exact deposition, but I know when it
Okay, but what you reported to me is that after he left, you went through the office and you found those paperwork.
yes,
And then you turned around and you gave it to the bankruptcy trustee.
I gave it.
Yes or no?
No,
No, you gave it to your attorney and your attorney gave it to the trustee.
I don't know.
Well, somehow or another, it got to the trustee, correct?
Yes,
And somehow or another, the trustee then arrests him, correct? Yes or no, ma'am?
maybe.
Maybe. Well, he got arrested, you just said it, right?
Yes,
And then you started claiming not to know anything about the Dubai property or anything about the accounts in Dubai, correct?
no,
Ma'am, you told me that you didn't know that there was any property in Dubai until you found those documents. Isn't that correct? That's a yes or a no?
No, that's not true.
Ma'am, you told me in your deposition that you and your husband have been visiting that Dubai property since early 2016 or 2017, when your kids were little.
Yes,
And now you want to claim that your husband has been doing all of these things behind your back, correct?
the title,
I didn't ask you about that, ma'am. Are you really telling this judge that you didn't know anything about that or any of the other transactions that he has been engaging in all of these years that you have been married?
Suleiman told me he had work in Dubai and businesses and
Objection, non-responsive.
Sustain.
So your story today is that you didn't know anything about this. Is that correct?
I knew a little about it.
But you're asking the court to undo this deed of trust that you signed, correct?
Yes.
And what do you think is gonna happen if the deed of trust gets undone?
The home was bought by Suleiman and myself personally. It was never a part of the trust.
Do you recall in one of the transcripts, ma'am, of the bankruptcy proceeding where one of the creditor is complaining, ma'am, that you and your husband, or rather your family, has lived very lavishly off of the trust?
Yes,
So if the trust was providing money to the community, or let's say to you and your family, does the trust not have a right to get paid back?
trust was not providing our lifestyle. It was Suleiman and I jointly. Our financials, our earnings, his earnings when he worked. That's how we used to live. The trust did not provide for us.
Okay, and the time that he wasn't able to provide for your lavish lifestyle,
Yes, my dad paid all our bills.
did your dad also buy that jewelry that you claim was stolen?
Objection made.
I don't claim.
Hold on one
jewelry was
second.
stolen.
Did your dad also buy that jewelry that you claim?
I'll rephrase that.
Okay,
In your proposed property division, you set out under number 71, husband's disposition of jewelry prior to bankruptcy, $4 million.
Yes,
You both talked about the jewelry in the bankruptcy case, correct?
yes,
You both filed paperwork with the bankruptcy court saying that there was no jewelry at the time of the filing of the bankruptcy.
yes,
You both testified to that, isn't that true?
yes.
Your father was even questioned about the jewelry and he claimed that it wasn't worth that much. Do you recall that?
I wasn't at my father's, but yes,
You know that they questioned your father about the jewelry.
yes,
You know that they had brought some claims against your father as well, correct?
Objection made.
I don't know.
Was your
hold on one second. Let me rule on that objection. Go back to it. You know that they had brought some claims against your father as well. Objection to Vegas to,
rephrase.
okay, sustain rephrase.
Your father came in or got involved in the bankruptcy, correct?
Yes,
And that was because it was alleged that he was holding property for the two of you.
I'm not sure why, but I know he paid the settlement for the bankruptcy.
Okay, and you know also that he has been involved in that trust lawsuit, correct?
Yes,
And because the trust supposedly has a claim against your father as well, correct?
supposedly, yes.
Do you know that in that civil lawsuit that they took a default judgment against your father?
Objection calls for facts not evidence.
I don't know.
Sustain.
Do you know if your father ever answered that lawsuit?
I don't know.
Okay, so you don't know if your father has been found to owe anything to the trust at this point.
Objection calls for speculation.
I'm asking you.
Overruled. You may answer it. The question was, so you don't know if your father has been found to owe anything to the trust at this point?
He has not,
You don't know, or he hasn't been found.
he has not been found.
Okay, but he's still involved in that lawsuit, correct?
Objection calls for speculation.
Sustain, unless she knows.
So ma'am, you initiated the lawsuit, correct?
Yes,
And you would know if there's other third parties that have come into the lawsuit, correct?
yes,
So has your father been brought in as a third party in that lawsuit?
yes.
Now, going back to the kids, you said that there were no concerns for your son, Isa.
Yes,
And it's fine for Isa to continue on the schedule that he's on, correct?
no,
So you have no concerns for your son, but you're asking the court to put your husband on supervised with your son?
I'm asking for Isa to be able to go and come as he pleases, because he will start driving in 6, 7 months. And he wants to have the flexibility to go whenever he wants or come home whenever he wants. He's asked me that.
Okay, but you understand that it's not up to your child, it's up to the judge.
Yes,
So I'm gonna ask you again, ma'am, if you have no concerns for Isa, is it fine for the schedule to stay as it is?
for Isa,
Yes,
that's what the judge feels, then yes, it's fine.
well, it's not hurting him or harming him, is it?
No,
You're working right now for Soho Construction, correct?
yes,
How much,
construction? SOHO, thank you.
how much do you earn
7,000,
a month?
yes,
And then you have a business called Clutch, correct?
yes,
And in your proposed property division, you put a value of the business of 1,310, correct?
yes,
And that was taking into account a $50,000 loan that the business owes, correct?
yes.
Owes to you.
The business goes to the bank, alone.
It says note due from what? $50,000.
Yes, I owe much.
Okay. Now, ma'am, later on in your proposed property division, you list the debt for the loan to Clutch 67, at number 67. Do you see where you've listed it twice on your proposed property division?
Well, I have to,
I'm not asking you that now. Do you see where you have allowed for that loan 2 times in your proposed property division?
Well, Judge, I would ask for the council to refer the witness to a specific exhibit. She should look at it.
Okay,
Number 2.
which, okay, it's in the binder.
May I approach and
Yes.
return there because there's a lot of paper, Judge.
are you referring to, there's.
Hold on 1 second, so you won't have to guess. She's
Okay.
gonna show you the exhibit.
So if you see, ma'am, on the first page, number 28, you put in the minus, I'm sorry, it's 30, the minus 50,000 there.
Yes,
And then on the next page, on number 67, you put the minus 50,000 there as well.
$67 is the 50,000, yes. But I owe to Clutch, but the first one is what Clutch
Not
owes
respond.
to the banks.
Sustain, hold on, ma'am, wait for the question.
You get that lowers the value 2 times by 50,000. That's a yes or a no, ma'am?
No,
Ma'am, also, in the net real property, number 10, you put in 4,905,000. Do you see that?
yes,
And then you divided that in 2 between you and your husband, correct?
yes,
That is before any of the liens are paid off on the house, correct?
that is before the tax lien, the property dues and fees, and the property tax.
Okay, so in reality, if the court sells it and divides it in half between you and your husband, both of you are gonna net approximately $1 million.
Maybe, yes.
That's not taking into consideration the money that's owed to the trust.
Yeah.
Correct?
Mhm.
Now, ma'am, you understand that this court has the ability of putting that money into the registry of the court and letting the civil court decide what happens to the trust.
Yes,
And you filed that petition to remove him as the trustee, correct?
yes,
And you were complaining about certain transactions that he has done with the trust, correct?
yes,
All of those transactions that you're complaining of are since the divorce was filed, correct?
yes,
You have no complaints about the transactions he did before, correct?
well, I learned through the bankruptcy, and so then I did have questions, and he had no job, and he was living off of the
Objection,
children's
not
trust.
responsive.
Sustain.
So ma'am, in that lawsuit that you filed in the civil court, you are complaining only about the transactions since the divorce was filed, correct?
Then I'm asking to remove him as trustee because he mishandled the funds of the trust.
He mishandled the funds. That case is still pending, correct?
Yes,
And you are asking to be appointed as the trustee?
initially we were looking for a company or a management, but the trust doesn't have the funding to do it, so I would have to, yes.
And you, as the person that wants to come in as the trustee, are asking to remove the lien.
Yes,
And let's be clear, ma'am, for the record, the beneficiaries of the trust are your 4 children, correct?
yes,
One of them that's sitting outside, Selena,
yes,
who is an adult at this point, correct?
yes,
And just for the record, Selena was allowed to go and come in between your residence and Mr. Hushman's residence, correct?
yes,
And that was even before her 18th birthday, correct?
yes,
And she chose to stay with her dad, correct?
yes.
And for how long was she estranged from you before she turned 18?
It was after when I didn't let her have the alcohol party at homecoming in October, so 6 months before she turned, or, yeah, because I said no.
Okay. Are you having contact with her now?
No,
How much time do I have, Judge?
You have 12 minutes and 38 seconds. Attorney Rambo, you have 4 minutes and 10 seconds. Attorney Kirkham, you have 40 minutes. Okay, Attorney Kirkham.
Very brief. You testified earlier regarding this bankruptcy proceeding, correct?
yes,
And that started in late 2021, correct?
yes,
And, it's virtually, yes.
Yes.
Yes, how did the place already? You turn to tab 3 of this exhibit binder, which you recognize that,
yes,
that is the engagement letter, well, sorry, that, who is retained to provide legal services on your behalf for the bankruptcy proceeding?
at that time,
Yes.
it was, Quillen Sealander,
Okay, so,
Who?
and that,
it was Quillen Sealander, Lounge Winslet, is that the correct name right now, or
It is.
before, okay,
so, and you signed that, right?
yes,
And that's been identified as, interveners into the.
yes,
You agree you were represented in the subsequent bankruptcy proceedings by Mr. Stanford, Paul Stanford. Is that right?
yes,
And that he represented you and your husband in the bankruptcy proceedings, in a manner consistent with that, agreement, right?
yes,
You testified that you estimate the value of the marital residence as approximately $4.5 million, right?
yes,
And your exhibit number 2 is your proposed property division. That's your exhibit.
yes,
You are seeking in petitioner's exhibit 2 in your proposed property divisions, that the home be sold and that, quote, all liabilities paid prior to disbursing funds to parties, unquote. Is that correct?
Yes,
Do you agree that outstanding fees for services would constitute a liability to the community estate?
yes,
If you independently reach an agreement to discharge a claim by the interveners against you for the liability arising from the bankruptcy service, right?
yes,
Do you understand that your husband has not?
yes,
Do you understand that that liability still exists?
yes.
And that's what.
All right. Attorney Rambo, anything further? All right. May this witness be excused back to her seat?
Yes.
Okay, ma'am, you may return to your seat. Counsel, you may call your next witness.
Thank you, Your Honor. We call Suleiman Hashmi in his capacity as trustee for the SMH Trust.
Okay. Same instruction, Mr. Hajmi. Just pull the microphone close to your mouth.
Judge, can I just put something on the record? Because something just came to mind about the trust.
Yes.
I don't remember what the provisions are once the kids age out. But if Selena is an adult and a beneficiary of the trust, I think what they're asking for would affect her as well.
And Your Honor, first of all, not today. Second of all, she has the ability to call witnesses, ask questions, and put on evidence regarding the trust. So that's on her, and she can use her time to do it.
But that's not the point, Judge. If they're going to affect her property rights, she is entitled to notice.
I object to counsel testifying at this point, Your Honor.
So just so the court is clear, you're objecting to what exactly? Or are you making note of what exactly?
Voicing my objections as to going forward on their request, Judge, to declare this lien void if it has any detriment or any effect on Selena's property rights. She's a beneficiary of the trust and she's an adult.
Well, if I'm understanding correctly from the onset when we spoke about this issue, what the court is being asked to do is to invalidate the deed of trust, correct?
That's correct.
So if that is the case, then wouldn't anything else regarding Selena or the children, as it relates to the trust, be taken up with the civil case?
Well, I think that if you invalidate the lien, Judge, then what happens with that money that is supposedly owed to the trust, the 2 whatever million? That money presumably is supposed to go back into the trust upon the sale of the home because it's a deed of trust on the marital property. And if you take that money from the trust, Judge, it's going to affect the 3 minor children and it's going to affect Selena, who is an adult now.
So if I were to invalidate the trust, if I were to invalidate the deed of trust, that would automatically make the money.
Your Honor, first of all, I would like on the record whether to determine whether Ms. Olvera is representing the trust or Mr. Hotchme when she's making this argument.
Judge, I am representing my client.
Yeah, I think she made that very clear that she was representing Mr. Hotchme.
Correct. That's what I understand. Okay. And also, she's put forth no evidence or no case law or nothing supporting what she just said.
It's a deed of trust, Judge. It's a deed of trust where they are deeding a property interest in their marital home to the trust. And they are asking to affect that. We have an adult child that should be part of this.
And Your Honor, we have a deed of trust that's invalid on its face.
I'm sorry.
Actually,
I was going to get to that with questioning with my 4 minutes left.
Okay. So it's noted for the record. You may proceed, counsel.
Thank you. Now, first witness.
Yes.
Showing you what is in evidence as wife's exhibit 122. This is the deed of trust that's at issue in this case, correct? Actually, let me back up a question. Your name is Suleiman Hoskin, correct?
Yes,
Yes, and that's the deed of trust that's, that issue in this case, correct?
I don't know if it's that issue in this case.
Okay, was the deed of trust, that was, you say on behalf of the SMH trust, correct?
Yes,
That's not a mortgage document, is it?
it's a deed of trust.
It's not a mortgage document, correct?
I think it is.
You're not a mortgage loan officer, correct?
No, no.
You can't make mortgages, correct? You're not licensed, correct?
You can make loans without one.
Objection, non-responsive. You're not licensed
Sustained.
to make mortgages, correct?
No,
You're not, this document is not property taxes, is it?
maybe.
It may be. It's not for OT partition, is it?
What did you just say? Sorry.
That document is not for an OT of partition, is it?
No,
It's not for a refinance of a lien against a homestead, correct?
it might be.
There was no lien on the property before this, correct? Didn't you testify, didn't your wife testify you paid cash for the property?
Yes,
So there was no refinance, correct?
there was, debts that we incurred on the property.
Objection, non-responsive.
Sustain. The question was, so there was no refinance, is that correct?
No, that's not correct. There could have been.
There could have been, okay? It doesn't say that in this document though, does it? In exhibit 122. Hey, what, last report takes judicial notice that the word refinance is not in the deed of trust. This is not a home equity loan, is it?
Yeah, it basically is.
It's a loan, is that's your testimony?
Yeah,
Okay. That document doesn't cover working material used in making improvements to a homestead, correct?
I think it did.
There was working material used, that document secured?
Yeah.
Who formed it?
I think it was done internal.
It was done internally. This is the first time you testified to this, isn't it?
Yes, I think so.
Okay, that's what I thought. It's not a reverse mortgage, is it?
No, it's not a reverse mortgage.
Nor, your, homestead was not a manufactured home, correct?
No,
So it wasn't a conversion or refinance of a, manufactured home, correct?
no.
Pass witness.
Right? Attorney O'Vera?
To Mr. Hashmi, your house is very nice. Would that be correct?
Yes,
This is your house on the screen, correct?
yes, it is.
Rather lavish, correct?
Yes,
After you and your wife moved in, did you make improvements to it?
yes.
What improvements did you make to it?
We did the kitchen, an outdoor kitchen, the flooring, HVAC, swimming pool. Improvements, renovations.
Okay, were you using some of the money that was contained in the trust accounts?
Yes,
Did you use the money from the trust accounts for other things?
yes.
What kinds of things?
So we basically carried out some of the expenses of our personal life when I had stopped earning money. And we had, in essence, borrowed against the trust against primary residence.
Okay, so to Mr. Hashmi, why did you have to file for bankruptcy in 2021?
So, a hospital that I previously owned had filed for bankruptcy and that just ruled, corporate bankruptcy and that yielded, a personal bankruptcy.
How much debt in total, if you remember, personal debt, were you carrying in 2021?
I think it was around $20 million.
Were you able to cover that debt?
No,
Were you making income from your businesses to be able to make those payments?
no,
Did you have property foreclosed on?
yes, a business property, you're talking about the business property, yes.
Now, you've heard a lot about this business health site. What is health site?
Health Science is a defunct company,
Okay, but what did it do when it was operating?
so it managed the hospitals.
Now, health sites, at the time of the bankruptcy, did it own property or material, stuff like that?
At the time of the bankruptcy, yes, it did.
What did it own?
It owned hospital equipment that was located in the hospital and in storage areas of the hospital.
Do you believe that that's where the trustee got the value of 3.75 million?
Objection, call for speculation.
Sustain.
Were you a part of the proceedings in the bankruptcy court?
Yes,
Did you talk or participate in hearings with the trustee?
yes,
And you saw the documents that your wife had admitted in this case where the trustee put a value of 3.75 million, correct?
Objection, compound and leading.
Let me rephrase, Judge.
Sustain, rephrase.
So in her exhibit, sir, that is marked as exhibit 90. May I approach, Judge?
Yes.
Now, this is a record of the assets and it shows health sites.
yes,
Objection, leading.
I'm just showing you.
Overrule.
Now, did that value come from the documents of the bankruptcy case that's in front of the judge today?
Objection calls for speculation.
Sustain unless he knows.
Do you know, sir, where the value came from?
I think it's from the bankruptcy.
Objection, speculation.
Sustain.
Where did it come from?
I think,
Objection asked and answered.
yes,
Sustain.
Didn't ask them that question, Judge.
Well, okay. He started off saying, I think. So even if it wasn't asked and answered, it was speculation again. Okay.
Well, that value is used on your inventory, correct? Do you remember that?
Objection, leading.
Sustained only.
Do you remember doing an inventory in this case?
yes,
Do you know what value was used in the inventory for house sites?
yes,
And where did you get that value?
the bankruptcy.
Now, at what point did house sites stop operating?
In the bankruptcy.
Okay, so that value, do you believe that the equipment that was owned, let me rephrase, how much value would you put on the equipment for the machinery that health sites own? Back then,
3.75, around $4 million.
what happened to all of that equipment?
All of that was turned over to the trustee.
Was it liquidated?
Yes, I believe it was liquidated.
Were there any other assets that the trustee took to pay off debts?
Yes, I think it took everything other than what was protected assets. That's the purpose of a chapter 7.
Okay, so what were you left with after the bankruptcy?
Just the primary residence.
And that primary residence has how many liens on it?
It has 2 liens on it.
Tell the court which ones.
So there's a lien of the trust and there's an IRS lien.
And the IRS lien is how much?
$1.2 million.
And then we have the lien from the trust, which is 2.5, correct?
Yes,
What do you believe the house could be sold for?
I believe it could be sold for 5.5.
Okay, so sir, I am going to show you what's been marked as exhibit 52, which is a transcript of a hearing that happened on March 15, 2022. Do you recall that?
Yes,
In this transcript, and I've highlighted it, do you discuss issues regarding property outside of the US?
yes,
What did you remember reporting to the trustee on this day?
that was consistent with what I told the trustee, which was there was real estate and bank accounts in Dubai and I debt in Dubai and everything was taken and frozen in Dubai as well.
And actually, the documents that your wife entered, did you declare in there the Dubai property?
Yes,
Did you declare in there the Dubai bank account?
yes,
Now, at that point, that bank account was frozen.
yes.
What happened to
Objection,
it? What happened to it afterwards?
It was taken
By whom?
by the creditors in Dubai.
So you have creditors over there as well?
Yes,
objection, leading.
Sustained only.
Okay. Judge, may I approach?
Yes.
I'm gonna show you what your wife marked as exhibit 88 and refer you to page 9. Does that specifically talk about the Dubai bank accounts?
yes,
Now, sir, other than the house and her business that's called Clutch, do you know of any other assets that are held in the community?
no,
Now, did you force your wife to sign that deed of trust?
no,
Okay, under what circumstance did you and your wife go and sign that deed of trust?
But we wanted everything left for our kids at that time, and it was just done for the kids.
The deed of trust,
Yes,
when was it signed?
it was signed in 2018, and it was basically to ensure that some of the money that we had taken out and that it would, in essence, pay for some of the renovations that were done, and it would be protected to the trust as well.
Did your wife know about all of this?
Yeah,
Now, you heard her say that she didn't know what she was signing. Is that correct?
I heard her say that, yes.
Did y'all go to an office to sign it, or where did y'all sign it?
I went to a notary and signed it in front of the notary.
Did you have the entire document when you went to the notary?
Yes,
And who prepared it for you?
I think one of the attorneys prepared it, I don't remember.
Did you have attorneys back then?
Yeah,
Now, you heard what she's asking for as to your children, correct?
yes,
And you know what the allegations are with your children, correct?
yes.
Has your, if you know, has your father ever been charged criminally?
He has not been charged.
Now, Mr. Hashmi, are you taking your children to see their their granddad?
Objection, Your Honor. I just want to be clear. I called Mr. Hashmi, as in his capacity as trustee for the SMH Trust. Is he still testifying in that capacity?
Counsel?
Judge, he's testifying not for himself.
Okay,
when-
so we, um, any questions outside of his capacity will be if they call him outside of that capacity, or you call him in your case in chief.
Okay, how much time do I have left?
You have 4 minutes and 53 seconds. Attorney Bean, you have 1 minute and 24 seconds. Attorney Kirkham, you have 37 minutes and 16 seconds. Okay, Attorney Kirkham?
I'll call Mr. Hashmi in that case.
Okay, perfect.
Nothing further for Mr. Hashmi in his capacity as trustee.
Okay. Are you going to keep him on the witness stand now in his capacity as dad, or are you all removing him off the witness stand for now?
We have nothing further for this witness in his capacity, and petitioner will rest at this point.
Okay, all right. Are you calling him first? All right, go ahead.
Okay, so sir, you heard what the allegations are regarding your father, correct?
Yes.
Have you taken your children to see their granddad?
Yeah.
What do you do to try to ensure that your kids are not going to have contact with your father?
I just make sure I try to coordinate with my family and make sure that they're not at the same place or at the same time that we're there.
Now, you heard Miss English talk about this Eid celebration.
Yes.
Where were you for the Eid celebration?
So I'm not quite sure which one, because Marjan took them to Eid celebration as well, where my parents were. And I'm not sure which one she was talking about.
And was that this year?
I don't remember.
Okay, when is Eid?
Eid moves with the lunar calendar. So there's 2 Eids per year. And it moves with the lunar calendar, so it's hard to say the exact date, but there was one that was a few months ago.
Okay, and that one that happened a few months ago, did you have an occasion to take your children to an Eid celebration?
Yes, I did.
Did you run into your parents there?
I did, and then I left.
Okay, how long were you there after you saw your parents there?
Not even 3 minutes.
Okay, now, sir, have there been any other occasions where you run into your dad and you have your girls with you?
No, actually, there hasn't been. I try to really ensure that there isn't. That was just somewhat random.
Okay, and it is correct that right now you're doing a 2-2-5 schedule
Yes.
with your kids, correct? And you take them home every night, correct?
Objection, leading.
Yes,
Sustained on lead.
What time do you take them home?
8 p.m. on Mondays.
What time do you pick them up?
8 a.m. on Mondays.
How long has this been going on?
I think over a year.
Now, are you asking the court to just revert to the 2-2-5 schedule?
Yes.
Mr. Hashmi, what do you think about keeping your daughter safe if the court puts in a provision that the girls cannot have contact with your dad?
I hold my daughter's priority as their safety as my priority.
Okay, so real quick, Mr. Hashmi. As to your son, Issa, there are no concerns with Issa,
Cool.
and you are still visiting him 2-2-5, correct?
There are just a few concerns actually with Issa that I thought about. His cousins from his maternal side are involved in drugs and abuse of like sports gambling. I've mentioned it to her before, which she gets mad at, and then she says, my family doesn't do anything. And it's something encouraged, and even handling of weapons in the house. Her dad would oftentimes have loaded guns all over the house.
And these are the relatives she has in Atlanta?
Yeah,
Objection leading.
Sustained, don't lead.
Are these, where are these relatives located?
Atlanta,
Now, you understand she's asking to move to Atlanta.
yes.
What do you think about that?
I think it's extremely dangerous. Her dad has threatened to kill me. He's been in jail for murder before, and I consider it a highly dangerous thing.
Okay. I'm gonna ask judge and save the rest of my time for my witness.
Okay.
This meeting was, oh, sorry. Ms. Hashmi, you heard Ms. Lopez testify earlier about the child custody evaluation, correct?
Yes,
She reached out to you in June or July 2025, about payment of the retainer, correct?
yes,
And you didn't pay the retainer, correct?
yes.
And, correct, you did not.
I'm correct, I did know.
In August, you did pay for a plane ticket for your girlfriend, correct?
No,
It's not what you testified in your deposition, is it?
I believe it is.
You're, actually dating somebody named Aisha Zafar, is that correct?
Yes,
And actually, you were asked in your deposition, do you recall purchasing Miss Zafar a plane ticket in August 2025, Mr. Hashmi? You said yes, correct?
it was charged on my card and she paid me.
Objection non-responsive. If you
Sustained.
paid for it on your credit card, correct?
Yes,
And that was a Health Sites credit card, correct?
I think the corporate.
Yes, the corporate Amex, correct? The
Yes.
one you said that the company doesn't exist, you're still charging on that credit card,
I've
correct?
already told Amex that it doesn't exist.
And objection non-responsive.
Sustained.
And actually, you went and joined her, on that trip, correct?
Her mother passed away.
Objection non-responsive. You
Sustained.
went with her on the trip, correct?
No, not with.
You met her in, Doha, correct? Or actually Lahore?
Yes,
And
Spell that.
Lahore, I have Lahore. What country is that?
Pakistan.
Okay, and so you met her there. And, you've paid some of the Health Sites credit card out of the trust, correct?
That was your last question. The question was, and you've paid some of the health science credit cards out of the trust, is that correct?
Yes,
Attorney Kirkham?
No questions for Mr. Hashmi at this time. I would like to call John Paul Stanford.
Oh, okay, okay.
One question.
Go ahead.
The ticket that you purchased for your girlfriend to travel to Pakistan, was that with some kind of understanding between you and your girlfriend?
yeah, she was devastated. Her mom tragically passed away. I paid for the ticket. She paid me back.
Okay, I'll pass the witness, Judge.
Okay. Nothing further for this witness, right?
Not at this time.
Okay. You may call your next witness, counsel. And you have 1 minute and 29 seconds left. Sure. Yes, off the record. You've been going in and out.
Another judge, I'm sorry to interrupt.
It's okay. How are you?
Good, and you?
Good. It's just this one?
Yes, Judge.
All right. Have a good day. You're welcome. Before we begin, how do you spell your name?
Leena.
Okay, thank you. I'm glad I asked because I was going to spell it totally different.
It's like,
All right.
I proceed, Judge.
Yes, you may.
Ma'am, state your full name for the court.
Selena Hashmi.
And you are the daughter of Mr. Hashmi and Ms. Hashmi, correct?
Yes.
How old are you?
19.
Now, Ms. Hashmi, was there an occasion recently where you were at an Eid celebration with your little sisters?
I don't know.
Okay, how often does Eid come around?
There's 2 Eids. The big one happens once a year, and then there's a half Eid, which also happens once a year.
Was it one earlier part of the year?
Sorry?
Was there one earlier part of this year?
Yes,
Were you at a celebration with your little sisters?
yes,
Did you push them?
no,
Did you force them to go see their grandfather?
no,
Miss Hashmi, do you know anything about the kind of jewelry your mom owned before the divorce?
some, yes.
And what do you remember about the jewelry?
There was a lot of diamonds and that sort of stuff.
Do you know what happened to all that jewelry?
She took it to Atlanta.
How do you know that?
We were on a road trip. She was very protective of the car, and then once we got there, I saw her lay it out for her dad.
Okay, so ma'am, have you seen her with any other jewelry since she took that to her father?
Um,
Do you have any contact with your grandfather?
I don't know if he does not speak to me.
Do you know why he doesn't?
Objection, call for speculation.
Sustain. Council, that was your last question. Any questions?
No, Your Honor.
All right. Ma'am, thank you so much. All right, Attorney Kirkle,
Yes, I called John Paul Stanford.
thank you. And council, before we proceed, do you need this
No.
screen?
I do not.
Okay. All right, council, you may proceed.
Thank you. Can you please state your name for the record?
Yes, John Paul Stanford.
And how are you employed, sir?
I'm a partner of the law firm of Quillen Sealander, Lowndes, Winslet, and Mosier, PC.
That's a lot of things. Can we just call it Quilling or Quilling Sealander?
Please.
There we go. How long have you been a partner with the Quilling law firm?
Been with the firm since year 2000, and I was a partner in around 2005,
And when did you get admitted to practice in the state of Texas?
1989.
And are you admitted to practice in any other jurisdictions?
Yes, in federal court, I'm admitted in northern, southern, eastern, western district.
Why is that?
Courts. I practice primarily in bankruptcy law, and bankruptcy is a branch of the federal judiciary. Also admitted to the Fifth Circuit and Sixth Supreme Court, and for a time I was also admitted to practice in the state of Arkansas.
What is your
Did you say Fifth Circuit or Sixth?
Fifth, the Fifth Circuit. Yeah.
what was your connection in particular to Arkansas for admission?
I went to law school at University of Arkansas in Fayetteville.
And then you've been practicing otherwise in Texas. Right?
That's correct.
And what is the focus of your law practice?
Well, it's exclusively bankruptcy. I represent a lot of different types of clientele in bankruptcy process.
And since we're in the family law forum here, although it's not necessarily unfamiliar for us, we briefly describe what your bankruptcy law is.
Well, of course, it always centered around the client. I represent Chapter 7 debtors, chapter 13s, also Chapter 11s, which are reorganizations. I do subchapter 5, which is small business reorganizations, as well as the larger ones. I also represent creditors in those cases, secured creditors, unsecured creditors. And I also do a lot of work for Chapter 7 trustees.
With the Chapter 7 trustee has been indicated in the testimony today. Very good.
That's great. In the case where I represent Ashby's, it was a Chapter 7 and Chapter 7 trustee, and Jeff Mims was appointed as the trustee.
Okay. Back to generally practice and assisting clients through bankruptcy proceedings. Is it always litigation?
Well, litigation is a separate part of my practice. I call representing debtors, and
I call it what?
it's a separate part of my practice. I represent debtors in the bankruptcy process, but also there can be adversary proceedings filed in bankruptcy cases, which follows more strictly the federal civil rules of civil procedure, and that's more of your traditional litigation.
Are you board certified?
Yes, I am.
What is your board certification?
In business bankruptcy law.
And what is your relationship to the parties to this divorce proceeding?
I represented both Mr. and Mrs. Hashmi in Chapter 7 bankruptcy filing in 2021.
And we discussed briefly that a bankruptcy. Don't allow you to explain again. What is a Chapter 7 bankruptcy?
Chapter 7 bankruptcy is your classic liquidation bankruptcy. It's where all the assets of the debtor are liquidated and distributed to creditors. Now, individuals, people file bankruptcy, they do get to keep their exempt assets, which are allowed under federal or state law, and all the other assets that must be liquidated by the trustee and distributed to creditors.
You have the exhibit binder in front of you.
Yes.
The interveners exhibits. Do you see what is a document that I've formed as interveners exhibit 3?
Yes, the Chapter 7 employment agreements.
Okay. And this is a copy of the Chapter 7 employment agreement with the Hashmis signed to retain Willing, Sealander, Lowndes, Winslet, Moser, PC for legal services, right?
Correct. This is my standard employment agreement, Chapter 7 debtors.
And what was the initial retainer?
$3,750.
What does this document indicate would happen in exchange for the initial retainer?
The basic work that comes in every Chapter 7 case, the preparation filing of the voluntary petition, the bankruptcy schedules, the statement of financial affairs, appearing along with the debtors at the first meeting of creditors, and generally keeping them advised as to the proceedings in the bankruptcy case.
And in particular, this document indicates, for example, that there would be, quote, analysis of the Hashmis' financial situation, rendering advice and assistance to them in determining whether to file bankruptcy petition under Title 11 of the United States Code and other chapters that are relevant to them, correct?
That is correct. We're actually required to go advise any client that wants to file Chapter 7. They do have alternative chapters to them, such as Chapter 13 or Chapter 11. Although in this case, that's one was a possibility.
And additionally, the document also states that Willing, Sealander would further perform, quote, attending and representing on behalf of Mr. Hashmi and Ms. Hashmi at the required 341 meeting of creditors, correct?
That's correct.
And what is the 341 meeting of creditors?
341 refers to the section of the bankruptcy code, section 341, that requires every debtor to appear before a Chapter 7 trustee, and also to have an opportunity for creditors to appear if they would wish to, so that they don't necessarily have to incur the cost of paying an attorney to show the court and ask questions of the debtors.
And on the second page of this document, it was signed on November 30th, 2021. Is that correct?
That's correct.
And there's a signature block there too for the parties, correct?
Correct.
And,
Both are signed.
and does that document indicate that Mr. and Hashmi both signed this employment agreement for Willing, Sealander and your services?
That's correct.
As Willing, Sealander's representation developed, what 3 areas or matters did that representation cover?
Well, of course, it started with the filing of the schedules, which were fairly extensive from the very beginning. Then we appeared at the first meeting of creditors. Creditors did appear. They asked a lot of questions. The trustee had a lot of questions that required the trustee to adjourn the meeting, not conclude it, but adjourn to continue to know the date. That's not unusual to have a second continued meeting. In this case, we ended up having 6 continued meeting of creditors, or 6 in total. That is a little unusual.
How is that unusual?
Usually everything is taken care of in the first meeting. If there's usually 1 or 2 things which are left unresolved, or still questions, or the trustee needs more documents, then the second meeting is settled. To have a 3rd and 4th is unusual. 5th and 6th is very rare.
Can you tell the court if you segregated these cases into unique billing?
I did. We continue to bill time for the meeting creditors, the production of documents that came up, and also for any issue of or exempt property. At some point, about 1 year, less than 1 year into the case, the trustee filed an adversary proceeding. Okay, that's a different proceeding, has a different case number. Okay, it requires a complaint by the trustee and it requires an answer.
Judge, at this point, it's non-responsive.
Sustain.
We
So,
did,
well, I'll ask my next question. So, what I'm getting to is, in the binder, do you see, exhibit 4?
yes, yes,
Okay, what is exhibit 4, just generally speaking?
but those are the time entries for work performed
Okay,
for the client.
now, did the Hashmis receive, in accordance with your employment agreement, periodic billing statements for services rendered?
Yes,
And did you personally review those billing statements?
yes,
Were those billing statements input onto a software system that you made sure that you verified for accuracy and so forth?
yes,
Okay. I observed with exhibit 4 that there's a distinct client ID number. And those vary. So we have the client ID number, first page of exhibit 4, 1301. 0.1470, chapter 7 cases. Then it goes client ID number 99000.001 Hashmi, Suleiman, and Marjanov. And then next issue is client ID number 9900.0002 Hashmi and Suleiman, or Suleiman and Marjanov, right?
correct.
So let's identify for the board what these documents and these distinct client ID numbers summarize.
Okay, 1301.1470 is for the main bankruptcy case.
And at page 4 of that document, you observe that there's a figure of 44,292 and 9 cents.
Correct.
What is that figure reflect?
That would be the number of hours spent by the attorneys times their billing rates for this matter.
And in these fee summaries of that statement, it identifies the time incurred for your services, correct?
Correct.
And it also includes identification of what the services perform, like a summary contract. So, then we move to the next client ID number 9900001. What does this cover?
That is for the proceeding filed by the chapter 7.
That is for the what proceeding?
The adversary proceeding filed by the chapter 7 trustee.
And that's been called in the pleadings the trustee NIMS adversary proceeding, correct?
Correct.
And likewise, there's identification on that, the billing statements of when services were performed, correct?
Correct.
And hours billed for the activities.
Correct.
And your hourly rate.
Correct.
And the hourly rate that you were charging was what?
$325.
So at page 10, we the trustee NIMS adversaries proceeding, we see that there's a grand total related to services there of $111,624.14. Is that correct?
Correct.
Now, regarding client ID 9900.0002, this related to work directly on behalf of the Hashmis with the IRS, right?
That's correct. That was a separate adversary proceeding.
Okay. You observe that there was a grand total there for services rendered of $1,235.
That's correct.
You agree that you were paid a sum of $25,000 to strike that. I'll move on to my next question, I'm sorry. The amount of a balance policy under claim to the intervention of pleadings amounts to $132,103.88.
That's correct.
Did Ms. Hashmi separately act to resolve the fee dispute?
She does.
Or it's really the fee balance, is that correct?
Correct.
Okay, now, as a result of that, we sought a partial non-suit of that claim, removing Ms. Hashmi, you understand that?
I do.
No. The amount that we are now seeking for the outstanding balance owed is $107,103.88, correct?
That's correct.
That is articulated in our exhibit 30, our requested relief. Did you see that? Dr.?
I did say that, that's correct.
So returning to the fee statements, you said that you personally review the statements for accuracies before it was sent to the clients, correct?
Correct.
How many other attorneys were involved in working on that?
In this representation, there were no other attorneys, just so.
Okay. Were there any legal assistants?
There was a legal assistant that did some of the work.
And you reviewed her time as well, correct? Okay. Who of the parties did you primarily communicate with regarding representation?
With Mr. Silverman, Hashmi.
And how would you and Mr. Hashmi typically communicate?
Well, both by telephone and by email. You know, we had a couple of meetings.
And what was the approximate duration of time that your work on behalf of the Hashmis, starting with the fee agreement on November 30th, 2021 to a conclusion? What was that duration approximately?
That was over a period of about 3 years.
What was the conclusive end of your services on behalf of the Hashmis?
I had to advise the clients that I would have to withdraw at a time when it appeared there was going to be additional work that was being brought by a trustee for non-payment.
And so the reason was non-payment, correct?
That was that was the initial reason. Once I learned a bit more about the action that the trustee was working.
Respond to this as well.
Sustain.
But the grounds for the withdrawal were what?
For non-payment.
Please turn to tab 6 of that binder. Do you see document there that is marked as exhibit 6?
I do.
What is that?
That's the email from myself to Silverman Hashmi.
Do you agree that that email, starting on the second page of the document, states, hopefully this will wrap up the matter. In regards to the calculation of legal services, notice that my billing rate for this representation was $325 per hour. I typically charge a higher rate for litigation, but the rate was carried over from the Chapter 7 file, where the rate is usually less important. By contrast, our opponents charged a much higher rate for their services. Chuck Henricks billed at $525 per hour, and Emily Wall charged $400 per hour. Did I read that correctly?
That's correct.
In this process, do you believe that the services you provided were not only less, well, strike that, were the services provided by you to the Hashmis actually less costly by an hourly figure than what the opposition was?
I believe very much so, yes.
In terms of quality, do you believe that you performed your ethical duty on behalf of the parties? Do you believe that the amount of fees for what was performed by you on behalf of the Hashmis were reasonable and necessary?
Yes.
Your email further addresses that what we were just talking about, the quote unquote normalize the bill. What does that mean?
Is where I go through with many of my clients and look to see where there may have been some redundancy work that was performed that shouldn't be billed twice. And try to make it more affordable for the clients and to encourage them with an incentive to pay the bill.
So it's your testimony that you gave them certain write-offs.
I do.
Is that standard for you?
Not fairly standard, yes.
Can you explain with particularity, you mentioned the 6 meetings that you had. So what was unique about this case?
There were allegations that there were assets that had not been disclosed. And it required them for my clients to respond to that. With my efforts, I had to move through that process.
Now, we reached an offer of settlement that resulted in a suit against Nissan, correct? Just only.
Yes,
To your knowledge, was a similar offer of settlement provided to Mr. Hashmi?
yes, it was.
Is that document reflected in Exhibit 29?
Yes, it was.
Are you asking that the court confirm a judgment in the amount of $107,000 or strike $107,103.88 against Mr. Hashmi to satisfy the payment for legal services rendered on his behalf by Quilling Sea Lender?
Yes,
Are you asking that this figure be secured against any reward Mr. Hashmi receives from the marital estate which is to be divided?
yes,
Were you present in the courtroom where Mr. Hashmi testified that he believed that the house could be sold for $5.5 million, correct?
I heard that less.
Do you believe that the residual, so, strike it. The parties seem to be in agreement that the house should be sold. Do you understand that?
I do understand that.
Do you believe that there will be residual proceeds upon which the outstanding balance owed to Quilling Sea Lender may be paid?
That's my understanding.
Pass witness.
Well,
I don't think it has any.
all right, so you race.
I'm gonna recall Mr. Hashmi.
I mean, not race, I'm sorry. So you're excusing this witness?
Yes.
Okay, Mr. Stanford, you may step down. Mr. Hodge, you may come back up. Counsel, you have 18 minutes and 12 seconds left. You're welcome.
Mr. Hashmi, you agree that you and your wife retained the services of the law firm Lien, Lowndes, Winslet, and Moser, correct?
Yes, yeah.
And the purpose of your retention of the Quilling Sea firm is to represent you and your wife performance of legal services pertaining to your Chapter 7 bankruptcy matter, right?
Yes.
Do you see that exhibit binder in front of you? You acknowledge that there is employment, the small one.
Oh, okay.
Oh, here, oh,
May I approach, Your Honor?
Yes.
thank you. That is the copy of the employment.
Bless you.
That is a copy of the employment agreement for services between you and your wife and the law firm Quilling Sea, correct?
Sorry, what time was that?
Tab number 3,
Yes,
and you signed that, correct?
yes,
And we agree the initial retainer amount was $3,750.
yes,
This document sets out, for example, that services would be rendered on your behalf, including quote, analysis of your financial situation, rendering advice and assistance to you in determining whether to file bankruptcy petition under Title 11 of the US Code and other chapters that are available, correct?
yes,
For example, this also states that Quilling Sea would further perform, quote, attending and representing your and your wife's rights that require 341 meeting records, correct?
yes,
And on the second page of that document that was signed, you acknowledge that that includes both your signature and your wife's signature, right?
yes,
Now, you understand that Quilling Sea representation is covered basically 2 areas, which Mr. Stanford testified to. Representation for the general bankruptcy proceeding, matters related to this NIMS adversary trustee proceeding, and then set additional internal revenue service adversary proceedings, correct?
yes,
And do you understand that billing on these 3 matters was segregated?
yes,
And did you receive periodic billing statements from Quilling Sea
yes,
And do you recall, Mr. Hashmi, that the billing statements would have a client ID number?
I'm not sure.
Okay.
Yeah.
Would you turn to tab 4 of the exhibit binder? Those are the fee statements covering services provided on your behalf. Do you understand that?
Yes,
Okay, so the first matter has a client ID, it's up at the top. That says client ID 1301.1470. See that?
yes,
Okay. And at page 4 of that document, you observe that there's a figure of $44,292.09.
sorry, anybody was in it for?
No, page 4 pages into exhibit 4.
Oh, Lord, okay, all right,
There's a it's confusing, I'm sorry.
Yes,
Okay. Now, on that page after it, there's a new client ID number. This covers the trustee Mims adversary proceeding, correct?
yes,
And there's an identification of dates, billing activity occurred, hours billed, and hourly rate, and so forth. You see all of that.
yes,
So at page 10 of this document, or this client ID 99000001, there's a summation of $111,000 or $111,624.14. See that?
yes, I do.
Now there's the final client ID number 9900.0002. This related to work on your behalf with the IRS, correct?
Yes, that's what it says to me.
Yeah. And then you observe that there's a grand total for services there of $1,235 connected with that funding.
Yes,
Now you paid Quilling Sealander a sum of $25,000, sorry, $25,047.29, correct? That was on or before October 25, 2025.
I don't recall.
Okay, so the amount of an outstanding balance owed to Quilling Sealander was $132,103.88.
Yes,
And the attorney who was working on your behalf was Mr. Stanford, who just testified.
yes,
You and Mr. Stanford communicated frequently by email.
yes,
Please turn to the 6th tab of that binder. Do you see a document that has been identified as Intervenors Exhibit 6?
yes.
And what is that?
It's a email exchange, it looks so.
Okay,
And it's an email exchange of what?
It looks like an email exchange, sorry.
and going to the second page of that exhibit, to the bottom, you observe that you sent Mr. Stanford at Quilling Sealander an email on Monday, June 19th, 2023.
The second page of,
Exhibit 6, yes, sir.
I don't have a second page.
Of Exhibit 6?
Yeah.
Approach.
Yes.
I don't know that.
That's fine. So. You wrote, sorry, John Paul, dealing with some personal stuff. We want to get you paid and can send you a bill so I can finalize something ASAP. You see that?
Yes,
And in response, Mr. Stanford provided a breakdown of the billing accrued on your behalf at that time, correct?
yes,
You were aware that Mr. Stanford even cut some of his time to your benefit.
yes,
And Mr. Stanford, as he confirmed, he wrote to, hopefully this will wrap up, it doesn't matter, we just testified. You agree with that?
yes,
Okay, now, your father-in-law made some payments towards legal services rendered on your behalf by Clemson, correct?
yes,
Please turn to tab 8 of the exhibit binder. Do you see a document there that has been identified as interview exhibit 8?
yes,
What is that? Is that an email exchange?
yes,
Okay. And that appears to be between June 21st, 2023 and June 22nd, 2023.
yes,
And on Thursday, June 22, 2023, you wrote, John Paul, I hope you are well. I'm embarrassed about asking you, can talk to him directly. However, I want to make sure this gets done. My father-in-law is asking if you can sometime give us additional discount, 45%. You see that?
yes,
And in response, Mr. Stanford responded, let me check. Thanks for keeping this, correct? So, Mr. Hushman, you don't deny that there was a contract for services on your behalf for the services that Quilling Sealander performed, right?
yes,
Have 10 of the exhibit by there's another email exchange, correct? Is that another email exchange?
Yes,
And that's communication between you and Amber.
yes,
Okay, so on June 28th, 2023, response to an email checking on the progress of payment, you wrote, quote, yes, I have been negotiating on his behalf. He is stuck at being like 60,000, or as it says in documents, it's okay, to settle this whole thing. And I'm working on him and told him how important this is. Is that correct?
yes, Judge.
And the him you were working with was who?
My father.
Can I clarify this point, further, that's your wife's father, right?
Yes,
Now, I noticed the string of emails exchanged. This correspondence is just between you and John Paul Stanford, same thing.
yeah.
Sorry.
Anyway, we can maybe to after.
Sure.
Thank
Yes. Okay, Attorney Kirkham, you have 8 minutes and 38 seconds left.
You're on, sir?
Huh?
Is there water anywhere?
Yes, there is a, by the, you know, the restroom is by the elevators, there is a water fountain there. Yes. Court is in recess for a few minutes.
you, Judge.
You're welcome. I needed to go too. So.
Before we, go back on the record, with this witness, I did just want to ask, before we give us a few minutes when we're done, to prove up the divorce, because I don't think we've actually done that.
Oh, that was in my notes for me to do.
Okay.
Yeah, I'll do it for you. You got it. You're welcome. Okay. Joy, let me know when you're ready. I can see you. All right, we're back on the record. And counsel, did you need your last question repeated?
No, I can move on.
Okay.
Mr. Buckingham, can you please turn to tab 15? You see an email exchange between you and Mr. Stanford,
Yes,
and whereas the other emails, I think, identify your name, this one shows POCC2@AOL.com. That's your, right?
yes,
And do you agree on the last paragraph of this document from Mr. Stanford to you? It states, quote, I've been upfront with you that I cannot continue to go further without payment of services. It has been over years since we concluded the dispute with the trustee, but I only received 2 payments from father-in-law. I cannot become more involved in another dispute that could go on for an indefinite period of time to get unpaid. Correct?
wait, where is that on 15?
It's at the last paragraph on that page.
Okay, yes,
And would you, Mr. Houshman, expect a person that you've contracted to perform services to stop ongoing work if you were not paying for them?
it depends on the situation.
So someone, you would expect them to continue performing services unpaid? That's your testimony?
No, that's not my testimony. What I'm saying is if there's a contract or something in place for them to be paid later or something like that. As a general question.
Okay. And in this instance, the employment agreement indicates that if you did not pay for services, that a withdrawal would happen. Is that correct?
I believe so.
Okay. Please turn to tab 26 of the binder. You see an email exchange there. Is that an email exchange?
Yes,
Between you and Mr. Stanford?
yes,
Okay. And did Mr. Stanford, on Thursday, October 3rd, 2024, identify to you the necessity of withdrawal of counsel, correct?
is this the email dated December 9th? Sorry.
October 3rd, it's exhibit 26.
Oh, 26, sorry, I was. Yeah, October 3rd.
It states, as advised, it will be necessary for the firm to withdraw as requested.
Yes.
We've gone through some correspondence here, Mr. Ashby, over a span of years' time, where Mr. Stanford and the Quillen Sealander firm were patiently seeking to work with you and come to arrangements for repayment for their services, correct?
Yes.
And do you agree that Mr. Stanford and the Quillen Sealander advocated on your behalf zealously?
Yes.
And you and your wife own real property located at 16525 Preston Trail Drive, Dallas, Texas, correct?
Yes.
And do you understand that your wife has alleged in her most recent sworn inventory and appraisement, which is identified as petitioner's exhibit 58, that a current fair market value for that home is approximately $4,650,000, correct?
Yes.
And you allege today that you believe that the home is actually a higher value, that it could be sold for $5.5 million. Is that correct?
Yes.
And that would be, there are liens on this property too, correct?
Yes.
An example is Dallas County, correct?
Yes.
And those liens would need to be satisfied, correct?
Yes.
Even residually with that satisfaction of liens, it's fair to say there's somewhere north of 2.7 to $3 million in equity on this home.
I'd have to look at the exact, I'm not looking at exact numbers right now, so.
Okay, so as it's alleged by your wife and her petitioner's exhibit 58, first sworn inventory and appraisement, she believes the approximate amount of equity in the home is $2,685,482. Do you understand that?
That's what she's doing.
That's what she's alleged. Do you understand that?
Yes.
Okay. And both of you are advocating for the home to be sold.
Yes.
That's what I'm saying.
Right?
Nothing further.
Nothing further? Okay. Sir, you may step back down. Do you have any other witnesses, counsel? Okay. All right. Back to my notes. I had a question. Why isn't the home insured?
Yeah, let my client.
Yes.
Preliminary was ordered to maintain home insurance, car insurance, all the insurances and all the med at the first hearing, but it was never done. It was canceled due to non-payment of provision. And because it was canceled for non-payment, nobody's willing to insure the home. Unless the payment.
It's been without insurance for over a year. And ma'am, you're the petitioner in this case, and you're currently married to the respondent in this case. Have you been a domiciliary of the state of Texas for the last 6 months? Have you been a resident of Dallas County for the preceding 90 days prior to filing of this suit?
Yes.
All right. Has your marriage to Suleiman?
Solomon. It's Suleman, so it's actually Suleiman, but everybody calls me Solomon.
Okay, Suleiman.
Yeah.
I got it. Has your marriage become insupportable due to discord or conflicts? Has it made the legitimate ends of the marriage relationship where you all cannot reconcile? All right. There are 4 children that were born or adopted of this marriage, correct? And 3 that are under the age of 18. Are you currently expecting a child at this time? Okay. Are you asking for a name change? What is your current name?
Like to be back to our time.
All right, spell your last name.
Yes.
All right. Are you requesting a name change to avoid any creditors or any criminal charges anywhere? All right. Are you asking the court to grant your divorce today?
Yes.
All right. Is there anything further? Okay, I believe that's all the questions that I have. I did have a question for you. The allegations that your daughters brought up, Do you believe your daughters?
Your Honor, they've talked to me about it to some length, and they said that the mother pressurizes them to say all these things. So they've brought up the flip to me, and I did not discuss any of the stuff with them. Because CPS literally had to conduct its investigation, and police, they also found nothing. So I would if my daughters ever said they're afraid to go there, or I would listen to them, but they literally grew up with my parents. My mom is an attorney, my brothers have young kids that live with my parents. My dad is a surgeon. I mean, like, this is, and I'm not saying that these things can happen. I mean, but I think it stems from initially, they basically voiced concern about her family, so she brought it in essence against my family. That's what I feel. The daughters would beg to be going to my parents' house, beg to be like, when can we see them? Even this allegation that was brought up about, oh, forcing them to write cards. Literally, I got a text from her saying, oh, you're forcing her to write cards. They were out with at home while I was at the grocery store, and my eldest daughter was home. And I was like, oh, is everything okay with the girls? They're like, yeah, they're just making Eid cards for the rest of the family. And that's what all I found. I was like, are they happy? Are they okay? And everything was fine. It was this thing, but at the end of the day, I would do anything to protect my daughter. And my eldest knows that, and even my son knows that. That's why he spends, the time with me.
What they said in terms of the counselor's testimony, she said that let me make sure I quoted her right. The fishy, did I say it right? She spelled it
Fishy, yeah.
Yeah. So what are your thoughts on them making that claim specifically?
So they've not brought it to me as something that, oh, they're like, they literally, after this happened, I came, the first time I saw them, and this is after I was instructed by attorney and CPS not to talk about it. They came home and they were like, are you mad at us? Mom forced us to go to the police station and report this. That was literally what I heard from them. So and even when I spoke to CPS and everything, I was like, if my daughters ever described a concern or ongoing issue with anyone, I would bring it up and I would protect them from it. I mean, it's just that, and unfortunately, this divorce has made things messier, right? And what happens is, if they brought up some allegation and that's where, yes, I mean, it's like so hard to figure out what's going on.
In regards to the home insurance, why didn't you keep up the payments?
So, Your Honor, I haven't had a steady job. I'm consulting on and off. The last job I had with my friend is the one who had actually lent the money for the cars that I previously had that were transferred over to Merjan. So that friend released the lien, but also said, look, I don't want to get involved in your legal battle, and he let me go.
Are you referring to the Maserati, the McLaren, and the Slingshot?
Yes.
So you don't have those anymore?
No, she had them and sold them. No, not the Slingshot, but she has the key and the power of attorney on the Slingshot.
Your Honor, I think he has a second Maserati.
He drives the Maserati right now.
What do you drive right now?
I drive another Maserati.
So it's not the 2020 Maserati?
This one is not the 2020.
He's 22 Maserati.
Yes.
Okay, when did you purchase that car?
That was purchased last October. And it was financed 100% by an outside bank.
I get it.
No down payment or anything, so.
I guess what I'm alluding to is that you had the funds to purchase a 2022 Maserati and you knew your home is not insured.
Yeah, I didn't have a car at that time. I'm just putting it together. So, and I don't want to interrupt you, but it was a 2022 Maserati that I purchased for $29,000 from a Ford dealership. I got 100% financing on it. I've not had more than maybe $2,000 in my personal bank account in any time period in this last couple of years.
So that financing, you're paying monthly on it?
Yes.
And Judge, if it helps the court, found some evidence in exhibit 128 and 132, how he obtained that vehicle.
Okay, I guess what I'm trying to understand is if you say you didn't have a car, you could have purchased any car. But you went and purchased such an expensive car, but the home, and it's a beautiful home, by the way, it's not insured.
Yeah, the problem is that, you know, home insurance on that home is like $35,000 per year. And even the order initially ordered on the insurance and the property taxes, it's to be paid from community property. So, well, it's almost like a circular reference where the only big asset after the bankruptcy is the homestead, which needs to be sold to pay for everything. And if it was like a normal size house where, oh, you know, $2,000 tax bill, $2,000 insurance, that's one thing, but
Yeah, but you knew that when you purchased the home, the location of it.
Your Honor, when I purchased the home, I was also making substantially more money. I never thought that, oh, I'm gonna be in bankruptcy in 4 years, you know, like.
So for 2 years, this house has been sitting uninsured. If something were to happen to it, then what?
That's why we've been petitioning for the last 2 years to sell it.
Okay. All right. And ma'am, I believe Attorney O'Vera asked you about the transactions where you said that husband was making a number of transactions not that you were not aware of. You responded and said something that you knew a little bit about them. What did you mean by that?
I learned about the trust transactions through the bankruptcy hearings because I would sit on them. And that's when I started to learn that there was no accounting, there was no real, when they would ask questions, the trustee, there was no answer that he had for any of the hearings for the trust. And that's when I started knowing, because I did not know anything about the trust itself, or other than when Issa was born, we opened the trust and we put $2 million in it. And he was going to invest that money, and that was the trust for the children. And it was to grow the 2 million. I didn't know about all the properties that it added into it or any of those.
Okay. Thank you. You also said that you would be willing, if the court were to allow you to move closer to Atlanta, Georgia, that you would be willing to pay for him to fly to see the children?
Yes.
Are you saying you don't want possession and access of the children by him to be exercised here?
I'm just worried for their safety when they're here with their grandfather, but I can come to and I can, if I have to be here for their well-being, I could.
Thank you. I didn't get the cost of the medical and the dental.
I can tell you what exhibit that is, Judge.
Okay.
It's
My opinion.
129.
I remember seeing the cards, but I don't remember seeing anything about the cost of the insurance.
If it's not in exhibit 129, my client can quickly answer how much she pays a month.
Okay. Ma'am, how much do you pay a month for medical insurance and dental insurance?
I have it through the marketplace, so it's discounted, but right now I'm paying about roughly $350.
That includes yourself and all the children?
Yes,
Okay.
because I've got all the dependents, Limon, Selena, Issa, and Sasha.
So it's 4 of you on there?
Five.
Five. Oh, okay.
So
Six total.
And sir, why do you believe that the home would be able to be sold for $5 million?
I just checked Zillow and I've talked to some realtors.
Even with the market they're still pretty confident that it could sell for $5 million?
At the end of the day, it is an estimate, but they're like, it should sell for 5.5 because it's almost 10,000 square feet on 1.5 acre, or 1.25 acre in Dallas. In a nice neighborhood, so these days it's still like there are surrounding properties that have traded before. I think they pulled some comps. That's how they came up with it.
Got it.
And I think that's what Zillow does as well.
Are there any bankruptcy proceedings pending right now?
So
That's all the questions that I have. So the court is going to render the parties divorced today. And I will get you all a ruling sent out. If not by this week, no, it wouldn't be the end of this week. You get it on Monday. I don't like to, today is Tuesday, but I do not like to send rulings out that go into the weekend because I don't like ruining anybody's weekend, the parties, the children, or the attorneys, because you all get phone calls. So you'll get a ruling on Monday.
Thank you, Judge.
Thank you all.